Good morning, everybody. It is now 9:30, so the inquiry is resumed. The arrangements will all be the same as they were on Friday. I hope everybody had a good weekend, and we'll carry on with the event. Is there anything anybody wants to add before we start with the examination in chief for the council?
Not from me, I don't think so. Thank you very much.
No,
Right.
not from me.
Good. Okay, well, that's very good. And if we could then continue, please, with the examination in chief of Mr. Daines. Thank you.
Yes, good morning, Mr. Daines. Can you see and hear me?
Good morning, Mr. Streeton. Yes, I can see and hear you.
And do you have in front of you your proof of evidence and addendum proof of evidence with appendices?
I do, yes.
And can you please confirm that those are true to the best of your knowledge and belief?
I can, yes.
Thank you. In terms of your...
Before we continue any further, then, can I just ask Mr. Daines to take the sworn after?
Yes, sir, I do apologise.
No, that was my fault for not. So I'll just get him to confirm it. Okay, Mr. Daines, could you say this after me, please? I do solemnly, sincerely, and truly declare.
I do solemnly, sincerely... sorry, say that again, please.
I do solemnly, sincerely.
I do solemnly, sincerely...
and truly declare.
and truly declare...
and affirm.
and affirm...
that the evidence I shall give.
that the evidence I shall give...
shall be the truth.
shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much. Thank you.
Thank you.
Thank you, Mr. Daines. So if you just please first turn up the summary in your proof of evidence.
Can you say that again? Sorry, please.
The summary in your proof of evidence. That's
Yes.
Paragraph 1. And it says there you are employed as a planning enforcement officer in the enforcement section of the Development Management and Enforcement Division. Is that still correct?
I'm sorry, Mr. Streeton. I couldn't actually hear you all that well. I'm just going to turn the sound up a bit. Could you just ask me that one more time, please?
Yes, I said it says there that you're employed as a planning enforcement officer in the enforcement section of the Development Management and Enforcement Division at the London Borough of Hackney, and I wanted to check whether that was still correct.
So I am employed by the London Borough of Hackney, but I am now in a different role in the council.
And what's your current role?
I'm an urban design officer.
But at the time when you compiled this proof, was this correct that you were an enforcement officer?
That is correct, yes, I was.
Yes, and in terms of your qualifications, you have a master's degree in urban design and city planning, is that right?
That is correct, yes.
And subsequent to that, you worked in planning enforcement at the council from 2018.
That's correct, yes.
Thank you very much. Let's then move on to the meat of your evidence, and I'd like to start with the planning unit.
Mm-hmm.
And I think the principles on that are well understood. Are you familiar with the principles relating to the planning unit?
I am familiar with them, yes.
Thank you. So firstly, if we could apply those principles arising from the case of Birdle and the subsequent cases to the building following the implementation of the 1994 permission, which you now accept was lawfully implemented, I believe.
On the balance of probability, yes.
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 So yes, if you could apply the principles relating to the unit of occupation and physical and functional separation to the building following the implementation of the 94 permission.
Yes, so I believe it was one planning unit.
And why is that?
Again, because of the single main purpose of the site at that time.
And then moving forwards, and we'll look at the evidence on this later, but in the period at some point between 2007 to 2020, your evidence is that there was a C3 use. Could you explain what you believe the planning unit would be if each unit was in, or each room was in C3 use?
That it would be 24 planning units.
And again, could you explain why that is?
So I believe it was 24 planning units based on the evidence that I had collected in relation to this case. So, I mean, that consisted of the fact that there were several council tax records for each unit, and that there were no obviously business rates for each unit or the site. Then obviously we have the electoral register showing that people were registered at the individual units. Obviously we served 24 enforcement notices on that point, and then obviously in addition to that, I've since heard that there are tenancy agreements for each individual planning unit, and obviously I'm aware that Mr. Hakimi had alerted me and emailed me stating that his tenants were resident, or maybe not resident, but his tenants were at the site.
Thank you. And we'll look at that in more detail later. Just sticking with the planning unit,
Yes.
the use of the site now, I don't think there's any dispute, is as Part C1 apartments. Could you please explain what you would assess the planning unit to be now?
I would assess the planning unit now to be 24 planning units.
And again, could you explain why?
Sorry, yes. Well, because obviously when the C3 use occurred, they would have become 24 planning units, and obviously that remains.
When you say obviously that remains, just thinking about that question of physical and functional separation.
Yes, well, exactly. So the units are physically separated, which obviously which wasn't the case previously.
And then finally, I'd like you to consider this question. As you'll have heard, there's the council's fallback position is that the site has a nil use.
Yes.
That the notice would need to be corrected to reflect that. Were that the case, were the notice corrected, or each of the notices corrected, what in your view would be the planning units in circumstances where each enforcement notice meant there was a nil use in relation to that area?
I'm sorry, Mr. Shreen, could you ask me that question again, please?
Yes, so in circumstances where the effect of the enforcement notices were to prevent the continued use as C1 apartment, and the site therefore it had a nil use, what would you say is the appropriate planning unit in those circumstances?
I would say it was one planning unit.
Can I just interrupt a second, sorry, Mr. Street, and Mr. Grant has raised his hand. Mr. Grant, do you want to say something?
So I'm sorry to interrupt, but you'll recall that the way in which the council's case was put, for example, in their opening, was that the council's primary position was that the lawful fallback was a C3 residential use. And in Mr. Daines's addendum proof of evidence, a different position was put in respect of nil use and the way in which that argument was constructed. And just on Friday morning, as I had understood it, what Learned Friend was confirming on Friday morning was that the position that was put by Mr. Daines in his addendum, namely that the council's position was the lawful fallback was nil use, was not the way in which the council were putting it. I understand the Learned Friend's argument that their primary position is that the fallback is lawful C3 use, but that if that's rejected, that they have a secondary position in terms of nil use. But the way in which the question was put, and I just want us to be careful about it so that I don't have 10 minutes unnecessary cross-examination on the point. The way the question was put to Mr. Daines was that you understand that the council's fallback position is nil use. And I hope my learned friend understands why I've raised it, just because that is not strictly the way in which it's put. And I just want to be clear so that we don't waste 15 minutes later on with me having to go around the houses on that point.
When I said fallback, I meant alternative fallback, and I'm sorry if that wasn't clear from my question.
Thank you very much.
I dealt with C3 first. The position is primary position C3, alternative case nil. I don't think anyone is seeking to demur.
Good. Thank you.
I'm sorry, Mr. Stratton. Can you go back to your last question, because I sort of didn't take a proper note of it. So I'd like
No, so that's absolutely fine. So my last question was, in that alternative fallback position where the lawful use is nil, what do you say the planning unit is?
And I said the planning unit is 1.
Thank you.
Let's then move to look at the evidence in relation to the factual history of the use of the site. And I hope we can do this fairly quickly because I did it in cross-examination in some detail. If you'd start with your Appendix 14, main proof of evidence, please.
Yes.
Do you have that?
Yes, I do. Yes.
Oh, sorry. If you let me know when you have the document, because I can't see when you've turned up. I apologize.
I was sorry. I don't know if it was. Yes. Okay. I will.
Could you just tell me what that is?
It's an application form for planning permission.
And to what does it relate, and by whom was it completed?
It relates to development at the site on Curtin Road, and it was completed by the applicant.
But when you say the applicant, specifically, if you look at box 1, who is it completed by and on whose behalf?
Oh, I see. Yes, it was completed by Mr. Martin King. Of Douglas and King Architects.
Yes, and on whose behalf was it completed?
It would have been completed on the legal owner's behalf.
If you could then look, please, at box 15, what does that say about existing use?
It says bar at ground floor level with residential accommodation on upper floors.
And when you look at box 18 as well, what do you take from those two together?
I take from those that the existing use of the upper floors was residential, specifically 28 houses or dwellings.
And if you look in box 26, on what date was that?
That was on the 8th of January 2013.
Yeah. Then if you could go to your Appendix 12, please.
Yes, okay.
And what do we find there?
So this is a delegated report from the London Borough of Hackney in relation to a planning application.
And who compiled that report?
A case officer by the name of Said Olokodana.
And what do you take from the second row left-hand column of the heading of the report?
The second row left-hand column. There was a date of a visit on the 26th of February 2013.
Yes. And then if you could look in the site description on the second page, second paragraph. What does that suggest?
Well, it states here that the last known lawful use of floors 1 to 4 of the site was a hostel. However, the application form refers to the upper floors as being residential, C3 use in brackets, 28 studio flats.
And then in the substance of the report, is there anything to suggest that that was inaccurate in the application form?
No, there wasn't. No,
Are you aware of any evidence that suggests that?
Am I aware of any evidence that suggests otherwise? No, I'm not.
Could you then go to your Appendix 15, please?
Yes.
And again, just tell me what that is, please.
So again, this is another application form for planning permission at the site.
And do you know the reference number or date for this application? What year did it relate to?
I do know that, but it's not on this page. It relates to application 2013 2670, I think. And what was this, number 15? Yes, exactly, 2670.
And so, what year would that application have been completed in?
That would have been completed in 2013.
And again, how in box 17 do we see the current use of the house described? Not the house, the building described.
Yes, so in terms of the existing use, it says 28 houses, existing market housing total 28, total existing residential units 28.
And then your appendix 13, please.
Yes.
And what's that?
So this is the delegated report for that same application.
And again, second row, left-hand column, what do you take from that?
Yeah, a visit was undertaken of the site on the 22nd of October 2013.
And who would have undertaken that visit?
It would have been the case officer, Barry Coughlin.
And if you could then turn within the report to, I'm afraid it's not page numbered, but to the body under consultations, internal, and then if you go on, there's private sector housing, policy and strategy, and then under that, finally, other matters.
Yes.
And what do you see from the first line of those other matters?
The officer states, notwithstanding the existing residential use.
And again, what do you take from the application form, the site visit, and that line together?
That the applicant and the case officer, based on the form and the case officer's visit, believe the site to be in residential use.
So in light of all of that evidence, please, that we've just looked at, in 2013, how do you understand the site to have been used?
I mean, based on the evidence I've seen, the site was in residential use in 2013.
And what sort of residential use?
Well, as 28 residential units. So, yeah, 28 private dwellings.
Now, you'd have heard in the evidence, particularly the re-examination of Mr. Sutton, he said, well, it was sublet under Airbnb, and that wouldn't have been obvious on a site visit. What would you say about that?
Wait, sorry, ask me that question again, please.
Mr. Sutton, particularly in his re-examination, said that at that time each of the units were being sublet on a sort of Airbnb basis, although Airbnb didn't then exist. And he said, and that wouldn't have been obvious if you went on a site visit. And I wondered what you would say about that.
Well, I would say, I mean, the evidence that I have seen still shows that the sites were 28 residential units. So I do not understand where the relevance is of that necessarily.
Well, let's put it this way. What evidence are you aware of to suggest that there was subletting, and consider in particular your appendix 18?
I mean, I haven't seen any evidence to suggest that.
Well, if you just look at your appendix 18.
Oh, sorry, okay. Oh, I see, sorry, okay, yes, please. Well, I have obviously this email from Mr. Hakimi where he stated that his tenants had been subletting it for Airbnb.
Do you know when that's said to commence? No. I mean, Mr. Hakimi did not state when that would have commenced. What does he say about the extent of any subletting that was taking place?
He states that some of the lettings had been in excess of 90 days per calendar year.
What's his overall suggestion as to the nature and extent of Airbnb subletting? What's the tenor of that email?
Well, he was saying that it was not C1, that the site was not C1.
Yeah. And so what do you take him to be asserting about the use of the site at that time?
That the site was in residential use.
And in terms of that email, who is Mr. Hakimi? Are you aware?
But based on our council tax department, they believe he has a material interest in the site. And I believe him to be the managing director of I think it's Metro's Properties Limited, who I think our council tax state have had an interest in the site for a number of years.
Thank you. If we could then go back to your assessment we have in 2013. Now look at your, sorry, at Mr. Sutton's Appendix 11, please.
Yes.
And what's that?
So this is a pre-application report.
Yes. And what would you like to say about that?
This pre-application report is for a change of use to the first and third floors to Class C1.
Yes. What do you take from that?
Well, this suggests that in 2018, that the site was not in C1 use. Otherwise, there would have been no need for a change of use to Class C1.
And is there anywhere in this reference to a retrospective application?
There is not, no.
And if we go to the site description and background, what does that say on the form?
Yes, so under principle of development, it talks of loss of residential use. It says loss of residential use, and it says that the current use of the upper floors is unclear. However, council tax records appear to indicate that the 28 unauthorised residential flats are currently in place at the site.
Yes, and we see similar wording, don't we, under site description and background?
Yes, we do, yes.
Who was it that was engaging with the council at this time in 2018? Who owned the site?
In 2018?
Yes.
It was the appellant.
And has the appellant been called to give evidence in this case?
They have, yes.
Well, rather than a planning agent, rather than
Oh, sorry, I see. No, they have not.
What do you take from that?
I mean, what do I take from the fact that they haven't provided evidence?
Yes.
That there isn't any, or at least not that I've seen.
And when you worked in enforcement and you were dealing with applications in particular in relation to lawful use,
Yes.
Did you have experience of the sorts of factual evidence that will be provided by applicants, say for Clwyd or Underground D?
Yes.
And could you give an impression of the sort of evidence you would expect to find from an applicant in terms of a factual description?
Yes, so tenancy agreements, other sort of financial documentation, things of that sort is what we would expect to see to confirm something like that.
And in this case, it's said by Mr. Sutton, oh, well, my client doesn't keep good records. What would you say about the credibility of that?
I believe first and foremost that I believe companies need to keep financial records for 7 years. I would expect there to be some form of record. So I don't consider there to be much credibility to the argument that these records do not exist.
And in your work in enforcement, have you ever come across the statutory declaration? Do you know what that is?
I do, yes.
And is there one in this case?
There is not, no.
And what would you say about that?
I mean, that suggests that there is not the ability for there to be a statutory declaration.
What do you mean by there's not the ability for that?
I suppose because there isn't evidence or a case to support one.
Right, thank you very much. If we could move on then, please, to your appendix 17, which deals with the council tax records you referred to earlier. Could you explain what that is and you think it?
So in relation to my investigation, I contacted our council tax department to understand, obviously having seen that council tax was being paid at each individual residential unit, I contacted them just to have a better understanding of the situation with that. And they confirmed to me that council tax had been paid at those sites since 2007.
What's the relevance of that?
That showed me that council tax is being paid, which is what would happen if there was residential use at each of the 24 sites, or each of the 24 units, sorry. And that also shows me that obviously council tax is being paid and that business rates are not being paid.
Now, the appellant says, well, that's happening today and everyone agrees the use is C1. What would be your response to that?
I mean, I suppose I would take it, considering the use on site now, as I understand it, that they should be paying council tax.
Well, you say they should be paying council tax.
I mean, they've been paying council tax since 2007.
Yes, and so what I'm asking you is that the appellant says, well, it's in C1 use now and we're paying council tax, so yeah, that suggests that that's not probative in relation to what the lawful use was. And I'm asking, what's your response to that? What does the fact that they're still paying council tax notwithstanding a C1 use tell you?
I mean, it doesn't tell me that it's not C1.
Oh, right. And then finally, your addendum, particularly appendix 004. Can you turn that up, please?
004. Yes. Is this the grounds of appeal? Is this what we're looking at?
No. Your addendum proof of evidence.
Oh, addendum proof. Excuse me. Sorry. Yeah. Yes. Okay.
Appendix 004. What's that?
That's an email from our electoral services from the government.
Could you explain what you draw from that?
Following conversations with them, they confirmed to me that individuals are registered to vote on the units as their permanent residents. And
what does that mean? The fact that those individuals are on that register in 2021. What does that inform you?
That informs me that there has been C3 use at the site.
Well, if we just go through your workings on that.
Okay.
What does the presence of a name on the voter register in 2021 mean? What does it signify?
But it signifies that at some stage there has been somebody has registered at the site as their permanent residency, and so that signifies that as of today, although that doesn't mean that they are necessarily currently at the site, but it states that they have at some stage in the past registered the site as their permanent address, so that it could be on the electoral register.
And why do you say it doesn't mean they're necessarily still present?
Well, I mean, I suppose it doesn't. It's not a list of people that have been on and are still on to this day. It's a record of people that have been at some stage. prior to the date in which I got the list.
And when you say that suggests C3 use, could you explain why that suggests C3 rather than C1 or hostile use?
Well, because obviously these individuals have registered the site as their permanent address, and obviously, you wouldn't do that if it was anything other than C3.
And could you do that at a hostel?
I think you can. You can register as a sort of proxy address, perhaps. I don't know if you can do that in a hostel or not. I don't believe in a hostel you can do it per room. I think you can. I don't know if you can register to the site as a whole, but certainly not as your permanent residence.
Thank you. So, looking at all of that evidence taken together and as a whole, firstly, what do you say about the suggestion that the lawful use of the site is still as a hostel?
I mean, I don't see any evidence to suggest that. I don't believe that to be true. And
just unpacking that, when you say I don't see any evidence to suggest that, has there since the 1994 permission been any change to the planning unit in your view?
Yes, there have. I believe there's been a change to 24 planning units.
And is that relevant when you consider whether the lawful use is still as a hostel?
Yes, it is.
And then secondly, in terms of the balance of probability, looking at all of the evidence in the round on the balance of probability, how likely do you think it is that there's been a C3 use, at least to use Mr. Sutton's word, at a point in time since 1999?
Yeah, I mean, based on all the evidence that I have collected and seen, I think on the balance of probability, it's very apparent that there has been C3 use at the site.
Yeah. And then a secondary question is whether that has continued for a period of 4 years. And you've seen the dates, the council tax in 2007, those first suite of reports in 2013, and then the pre-application in 2018. What do you take from that in terms of whether there's been 4 years continuous and active use for residential purposes?
I say the evidence says that there has been, yes.
Were you considering serving an enforcement notice against C3 use if that continued? Would you deem it appropriate to serve an enforcement notice against continuing C3 use in light of all of the evidence that you've seen?
No, I would not.
And why not?
Because the C3 use would be lawful, and so I would not be able to serve an enforcement notice.
Right, thank you. Let's then consider the grounds. Firstly, the ground B. If the use is C3, what effect does that have? If the C3 use was lawfully established, what effect does that have on the appellant's ground B?
If the C3 use was lawful, then the matters have occurred.
What if it wasn't lawful? So what if the lawful use is in fact nil?
How would that be for the ground B? We obviously have evidence of material change of use to C1. So, the matters have occurred.
But that would obviously require a correction to the notice. What do you say about whether or not the inspector can correct the notice without injustice?
I do not believe there would be any injustice based on what the notice required.
And why do you say that?
Because the notice only required the cessation of the C1 use. And so obviously, because it only required the cessation of the C1 use.
And have other fallbacks, if I can put it like that, including nil use, been addressed in the evidence on the other grounds? That's grounds C and A.
Yes, they have. Yes.
Moving on then, in terms of ground C, 3 different scenarios. 1 is that lawful use is C3, 2 is the lawful use is nil, and 3 is that the lawful use is as a hostel. If the lawful use is either nil or C3, Mr. Sutton agreed with me that ground C must fail. What's your position on that?
Yes, I agree with that position.
Okay, so the situation I want to consider then is the circumstances in which the lawful use is as a hostel, and the question is whether there's a material difference between that and the C1 use in place. You have as your appendix 16, if you just turn that up, please. It's the guidance on changes of use which has been withdrawn from the ODPM.
Yes, okay, I have that in front of me.
And if you look at paragraph 62, it refers to the case of Panayi, and it sets out a series of factors.
Yes.
And I just wondered if you could go through with reference to those factors and explain what, if any, material differences you perceive between the uses present and the hostel use under the 94 permission.
In comparison to the uses noted on site, you mean?
Yes, so the current use as against the 94 permissions hostel use with reference to the Panayi factors.
Yes, okay. So the first one is the presence of dormitories and or communal or shared facilities. Following my 2 site visits, I did not witness any dormitories or communal or shared facilities.
Well, there weren't there, laundry rooms, is that right?
I did evidence 1 laundry room, yes, on the 4th floor.
And so if you could turn up your appendix 5, and in particular pages 39 to 41.
Yes, okay.
And what do those show?
These images show the laundry room that was used by the cleaner to service the apartments.
And you say used by the cleaner. Why do you say that?
When I was on site, it was clear to me that this room was in use exclusively by the cleaner. In fact, she was using it at the time of one of my visits. That there was nothing to indicate that this room was to be used by anybody other than the staff member or the cleaner on site.
Yes, and Mr. Sutton in his evidence picked up on your reference in the note to an open laundry room. What did you mean by that?
So I mean, as the image shows, when I attended the site, the door was open, and so I was referring to the fact that the room was open at the time of my visit.
Thank you. Do any of the units have washing machines in them?
Yes, they do.
And what, in your view, does that suggest about the likelihood of those units using communal laundry facilities at all?
I mean, firstly, I don't think any of the units use the laundry facilities on the 4th floor. There's no indication of that. There's no signage anywhere in the building pointing to those like there is the other units. I don't know how anybody would even know they exist. But obviously, the fact that some of the units have their own washing facilities further goes to the point that I don't think those units certainly wouldn't. But I don't think any were or are.
Thank you. So if we go back to the Panayi factors in your appendix 16, and as I say, deal with the first of those factors, dealt with shared facilities and the presence of dormitories. What about servicing? Is there servicing here?
I mean, there is an element of servicing, yes. I mean, in so much as obviously when I was on site, I did see a cleaner cleaning rooms and sort of corridors, and obviously doing the laundry, cleaning the linen at the time. So I did evidence elements of services.
And is that, in your view, determinative of whether or not this is, or there's a material difference between a hotel and a hostel? The fact that there's servicing both NC1 and use.
No, I don't think it is.
Thank you very much. Secondly, then, accommodating specific categories of people, including the young and the homeless. What would you say about that?
I mean, certainly there was nothing to indicate from my site visits that the site was specific for any category of people, certainly not the young or the homeless.
Thank you. And then in terms of the making of payment, we know a payment isn't made by the local authority. Is it made on a nightly basis?
So as I understand, it's not made on a nightly basis. I believe that you can book the places on a nightly basis, but I think payment is made in one go.
But in your view, is that the payment is made in one go, booking on a nightly basis?
I'm sorry, you broke up there, Mr. Streeton. Could you say that one more time, please?
I said, in your view, is that actually relevant, the fact that payment is made in one go rather than booking being nightly, if that makes sense?
I think it could be. I suppose of all the distinguishing features, it might not be the most important one, but I think it is of some importance. Yes.
Well, what weight would you give to that?
What, the fact that it's booked nightly but not paid nightly?
Yeah.
Well, I would say it has some weighting. It helps distinguish between a hostel where you would pay nightly and the C1 use where you don't.
I mean, would you necessarily pay nightly for a hostel, or could you book nightly and pay at the end for a hostel?
I suppose you could.
Yeah. So overall, what weight would you give that in your analysis?
I mean, it's certainly not the biggest factor. It's small in comparison to the others. It's less in comparison to the others, I should say.
Yes. Next, transients, and we saw in the report in the issue of the enforcement notice reference to the word transient, but in the context of the Panyai factors, what do you say about transients?
Yeah, obviously. So, I mean, I guess in terms of Panyai, and transients refers to people that are placed, and obviously, when I refer to transients, I do not refer to people that are placed, but those that are visiting, as in, on holiday, or coming to experience the nightlife of Shoreditch. That's what I refer to in that respect, not in terms of somebody placed as it states in my appendix here.
Yes. And then finally, could you please turn up the Westminster case, which I think you appended to your addendum, did you?
I did, yes.
By me. And look at paragraphs 6 to 7 of that.
Which paragraph, sorry?
6 to 7 of that, and just read those to yourself and tell me when you have.
Okay, yes.
And you see there reference to it being of the essence that a hostel is basic and inexpensive. Could you look at your appendix 6, please? The online advertisements.
Mhm.
And we see a number of images showing each of the units.
Yes.
And what would you say about the level of furnishing for those units?
I mean, I would say it's high and of high quality. And yeah, and not inexpensive. or basic.
So what Mr. Grant and Mr. Sutton discussed in their re-examination was something being basic but nevertheless of high quality. Would you care to comment on whether you regard what's provided in these units as being basic but nevertheless of high quality?
I mean, I would say it's certainly not basic. I mean, in terms of even the imagery that refers to some of the utilities in each of the rooms. I mean, it's certainly beyond basic and quite substantial in terms of the amenities that exist within each of the rooms.
And when you're talking about that, I mean, could you just describe what you are identifying in those pictures as going beyond basic? Are there any items that you would say go beyond basic?
Well, I would even say the fact that there's sort of, the fact that there are couches, there are sort of like flat screen TVs, there are sort of, pots and pans, high end, there are washing machines, there are power showers, there are, fans, high end microwaves are advertised. They're highly decorated in terms of, the quality of the materials in the room. So I would say, they're certainly not basic.
And in terms of the beds, are they what sort of beds does one see in many of the rooms?
They're double beds, or large beds.
And just looking at the first image, the left-hand side, what do we see in terms of storage space?
There is a wardrobe. So there is good amounts of storage space.
And so looked at in the round against that basic and inexpensive criterion, what would you say?
I mean, I don't think they are basic or inexpensive. I think they are not basic, and I think they are quite likely expensive.
Thank you. Last point on ground C, and then we'll move to ground A. It's been agreed that there was a change to the planning unit following the 1994 permission. Is that change to the planning unit relevant to ground C?
Is that change of the planning unit relevant to ground C?
So when you're considering whether there's been a material change of use,
yes,
is the fact that it's gone from one planning unit to multiple planning units relevant?
Yes, that is relevant. Yes.
And why is that?
Because the change in planning unit is a material consideration in terms of whether there has or has not been a material change of use or a breach of planning control.
Thank you very much. Let's move then to ground A, please. And I think we need to consider this across three scenarios, which is residential use being lawful for each unit, hostel use being lawful across the first and third floors, and ill use being the lawful use of the first and third floors. First, I'd like to deal with the lost hostel accommodation, and in particular look at policy H8, please. That is, I think, in one of your appendices.
Yes, Appendix
8.
Yes.
Would you care to comment upon paragraph B of H8 in the context of the lawful use being as a hostel?
In terms of the loss of the hostel?
Yeah, so if what's proposed is a change of use from hostel to C1 apartments,
Yes.
apartments,
Yes.
what do you say about the relevance of paragraph B of H8?
Well, it states that if that is the case, hostels that meet an identified need should be satisfactorily provided.
And in this case, if we look at the 1994 permission, which is appendix number 8 to Mr. Sutton's proof of evidence.
Yes.
In accordance with that permission and the conditions attached to it, who can use the accommodation, or who could have used the accommodation consented in the hostel by that permission?
Who could use the hostel consented by this permission?
Yeah, so look at condition 6, and then what are the restrictions on who can use the hostel?
Oh, I see. Yeah, the hostel hereby permitted shall only be used to provide non-family accommodation.
So families can't use it, but who can?
I suppose anybody else.
So would that, applying the test in policy H8B, be capable of meeting an identified housing need?
No, it wouldn't.
Why not?
Well, I suppose. I mean, if it doesn't provide non-family accommodation, then obviously that is a housing need that is identified.
So sorry, I've now got confused. I'm sure it's me. If it provides non-family accommodation, is that capable of meeting an identified housing need? I.e., is there an identified housing need for non-family accommodation?
Oh yes, there is a housing need for non-family accommodation. Yes.
So would that permission be capable of meeting an identified housing need?
Yes, it is. Sorry, yes, I'm just reading both now. Yes, it is.
So then, if you could turn to apply policy H8, if you change from a hostel to C1, what is the effect in terms of accordance or non-accordance of H8?
Well, there is the loss of housing that meets an identified housing need that hasn't been satisfactorily provided, so it would not be in accordance with policy H8B.
And so overall, in terms of this policy, not the development plan as a whole, but this policy, would that development accord or not accord with the development plan?
It would not accord.
What about if the lawful use was a C3 with reference to paragraph A of policy H8?
So yeah, again, it would not accord because obviously policy H8A refers to the loss of existing housing, which should be replaced by new housing at existing or higher densities with at least the equivalent level of overall floor space.
Yeah. Let's then turn, please, to policy LP20, or LP12 of the local plan first, which I don't think is appended to your proof of evidence. So was this sent through to you?
I can pull up a copy of it.
So did you receive this over the weekend?
I haven't received it actually. I've checked my emails this morning, but it hasn't come. But I understand what you're talking about. So carry on. But if it can come through,
yes, no, that I'll make sure if it hasn't been sent that it
yes,
immediately.
Yeah,
I haven't received anything. Which document is it, Malone Friends referring to?
It's LP12 in the local plan.
Got it.
No, just check.
I haven't received anything, but I've got the policy anyway.
Grateful. Mr. Daines, do you have that LP12?
Yes, I do.
And could you explain the relevance of that policy in the context of the site having a lawful C3 use, if that is found to be the case?
Mm-hmm. This LP12 refers to meeting housing needs and locations for new homes. The council will plan to deliver a minimum of 1,330 homes per year up to 2033 by encouraging development on small sites and through allocating sites for residential use, increasing the supply of generally affordable homes alongside community facilities through high-quality urban neighbourhoods to meet Hackney's needs.
And then look at, in particular, at subparagraph D. What does it say there?
Self-contained residential units are the priority residential land use in the borough and type of land use for which there is the greatest need. Proposals involving the provision of other forms of residential accommodation, including student housing, visitor accommodation, and alternative forms of accommodation will only be permitted where applicants can demonstrate that it is not feasible to deliver C3 residential development on site.
So if the lawful use of the site here were to be C3, what would you say about the relevance of this policy?
Well, I would say that this shows that would show that it is feasible to deliver C3 residential development on the site, and therefore a visitor accommodation could not be permitted because that is the case.
What about if the lawful use of the site, and as we've explained, you say the planning unit then would be the first to third floors. What if the first to third floors were all in nil use? What would be the relevance of subparagraph D of policy LP12 then?
If the use was in nil use?
Yes. Would it be appropriate to grant planning permission to change from a nil use to C1 use in light of subparagraph D?
No. I don't believe it would.
Why not?
Well, because that still wouldn't demonstrate, whether it was feasible to deliver C3 residential development on site or not.
Yeah. Thank you. Let's then look to LP24, please, which is in your appendices. It's Appendix 10.
Yes. Okay.
And what do you say about the application of that policy in this case?
In the case of C3.
So yes, started with C3 being the lawful use, and then move to nil being the lawful use, and explain it in both contexts.
Okay. So yes, if it's okay, I'm just going to quickly read the policy.
Of course.
Yes. So in terms of, sorry, hold on. Yes, so in both cases, they would not be in accordance with this policy.
And why not?
Firstly, the first point is the land or buildings are no longer suitable for residential use, and it is considered inappropriate to provide residential accommodation. So in either case, that is relevant. And replacement of housing of an appropriate type is being provided at either an equivalent or higher density. So that would be relevant in terms of the C3 use. I mean, in all cases.
If we look at sub 3 and sub 5, refer to redevelopment necessary to create better quality homes and dwelling mix and improve the living environment as part of major regeneration schemes in that context, or enable substandard units to be enlarged to meet residential space standards. What does that suggest about the approach of this policy to substandard units and granting consent for the change of their use?
Yes, so it makes provision for that, in the case of to create better quality homes and dwelling mix and improving the living environment, or as part of major regeneration schemes, or to enable substandard units to be enlarged to meet residential space standards.
And so would, in your view, turning substandard units in terms of space into C1 accord with the intentions of those aspects of this policy?
Into C1, no.
And if there were a nil use, would it be relevant? Would this policy be relevant?
If it was a nil use, yes, this policy would be relevant.
Again, why?
Again, because it talks about whether the land or buildings are no longer suitable for residential use, and they are suitable for residential use, so I would say.
Thank you. Could we then go to LP25? That's your Appendix 10.
Yes, okay.
And in particular, so this is the policy dealing with visitor accommodation in the local plan. In particular, there's a criteria-based policy at C, and I wondered if you could comment on C3 and the criterion there.
So it states not result in the loss of general purpose housing or opportunities to provide conventional C3 housing or employment uses in line with policies LP12 housing supply and LP26 new employment floor space.
What do you take from that?
That obviously this policy refers to the acceptability of proposals for new visitor accommodation, providing that that there isn't a loss of general purpose housing or opportunities to provide it.
So with the position taken in turn C3 or nil, what do you say about the effect of this policy?
I would say that it would not be in accordance with this policy because of that.
Thank you. I'd now like to please go back in your proof and look at LP2, which is your Appendix 9.
Yes, okay.
That deals with development and amenity. What's the relevance of that policy in this case, do you say?
This is relevant in terms of the amenity impacts of the different uses at the site.
And could you just comment on what you say are the amenity impacts of a C1 use rather than a C3 use?
Yes, so the amenity impacts in relation to a C1 use as opposed to a C3 use is obviously because of the increased footfall of people coming and going. In addition to the services, you would see a greater level of sort of amenity impacts in relation to noise. That would be one point. And then also that you wouldn't have with C3 housing, and obviously then you'd also have the issue in terms of fumes and odour and noise from the increased footfall. You know, the transience of the occupants in comparison, in addition to any sort of refuge or any other elements to facilitate that use.
Thank you very much. Shall we also then just look at the management plan as it's presently proposed? That's Appendix 12 to Mr. Sutton's proof of evidence. What would you say about a management plan in these terms, in terms of its ability to control impacts on residential amenity?
Yeah, I mean, I would say it would not be able to.
Why?
Well, I mean, I don't see how that would be able to be controlled.
So if you look at 1.1, for example, and the times for responses
Yes.
to complaints, what do you say about that?
Well, I mean, looking at it, it doesn't seem adequate to be able to address, I mean, for example, there is sort of large gaps or in terms of response times or when complaints are made. And so it would not be possible to sort of consistently manage any of those immunity impacts which are addressed in that policy.
And is there any suggestion of on-site presence in that policy?
There isn't, no.
Let's then finally turn to policy E10 of the London Plan, which is the policy relied upon by the appellant in support of the provision of visitor accommodation.
Which appendix is that? Where is
Sorry, that's not in an appendix. That's another
sorry.
document that's not appended, but referred to in the appellant's proof. It's in the London Plan. If you have it in hard copy on page 273, and if you have it electronically on page 288.
E10, did you say?
Yes.
Yes.
Do you have that?
I do, yes.
And just looking in particular at paragraph H of that policy, what do you say about whether the proposal in this case would accord with policy E10H?
Mm-hmm. Yeah, I would say it is not in accordance with that.
Thank you very much. So then, overall, in terms of this policy, there may be other aspects with which it accords, and if you just read it to yourself and make sure you're familiar with those, what do you say about the level of accordance or non-accordance of providing visitor accommodation under the Ground A?
Yes, and the question was in relation to this, sorry?
So overall, what do you say about the nature or extent of any departure from this policy? Is there one, and if there is one, to what extent?
Oh, well, there is departure from it, and therefore I would say that it would not be in accordance with this policy.
Thank you. All right, then let's consider the overall position. Firstly, if the use is nil, changing from nil use, which is the council's alternative argument, to C1 use, looked at in the round, do you say that the proposal would accord or not accord with the development plan policies we've looked at?
I would say it would not accord.
And to what extent would you say it doesn't accord with the development plan read at the bottom?
Well, again, I mean, in terms of the accessibility, in terms of the wheelchair access,
and also the other policies we looked at, so LP24, LP25.
Oh, I see. Sorry, all of them. Yes. No, I would say in relation to all of them, it does not accord, and therefore it is not in accordance with any of those, or them read as a whole.
And what would you say about the extent of any departure?
I would say it's quite substantial, the departure from the development plan.
Thank you. What about if the lawful use is C3?
I would say it's not in accordance, and again, it substantially departs from those development plans, or the development plan.
And what about if the lawful use is as a hostel? Would you say accordance or non-accordance?
I would say, non-accordance.
Would the extent of that non-accordance be greater or lesser than if the lawful use were either residential or nil?
It would be. Sorry, ask me that question again, please.
Would the extent of the non-accordance if the lawful use were as a hostel be greater or lesser than if the lawful use was C3 or nil, which you said would be a very substantial, also not very, you said would be a substantial departure from the plan?
Yeah, it would be. It would be lesser. It would be lesser than those.
But still, what do you say about the extent of the non-accordance?
It is not in accordance.
Thank you. So we now need to look at other material considerations, and the other material considerations identified by Mr. Sutton were the need for C1 use. What do you say about whether those would outweigh any non-accordance with the development plan?
I would say they wouldn't outweigh them.
And then just one final question on that. One of the things the appellant says is that if the lawful use is C3, then those C3 units are substandard. Is that relevant when you consider the other material considerations aspect of the balance?
I don't think it is. No.
Why not?
Well, I suppose the relevance is the fact that the plan does allow for the enlargement of substandard accommodation, so it's relevant in that case.
But would that, in your view, be a reason to depart from the plan?
Would that be a reason to what? Sorry.
Would the fact that the units are substandard
Yes.
be a reason to depart from the plan, as you said would happen if you granted planning permission for C1?
No, it wouldn't.
Thank you very much, Mr. Daines. Oh, I should just briefly ask you about ground G. Do you want to comment on ground G? Deal with it in your proof of evidence, paragraph 7.52.
Just bear with me. I'm just familiarising myself with my proof.
No, that's fine.
So what was the question? Sorry, in relation to.
I just wanted you to explain to the inspector your position on the ground G appeal.
Oh yeah. Well, I mean, my position is that the 1 month compliant period was satisfactory in relation to this case, and that the ground should the appeal on that ground should fail.
And why do you say that?
Only because, well, not only because obviously, I appreciate there is perhaps maybe economic benefit to the use of the site, but there is no public benefit, and so I cannot see why they couldn't comply within 1 month. It doesn't stop them from reverting the use back to what the lawful use was.
I mean, if that use is nil, what would be the effect of it?
If the use was nil,
Yes.
well then they would just have, within that 1 month they would just need to cease the use as C1.
But what would be your position on ground G in those circumstances?
I mean, I think it's wholly reasonable to cease the use of C1 in that time period.
Thank you very much, Mr. Daines, those are all of my questions. But if you wait there, I suspect Mr. Grant has some questions for you.
Thank you, Mr. Stretton. Mr. Grant, I think I'll probably take a break now, and then that will allow you to carry on with your cross-examination. So we've been an hour and a quarter. So it's 10:45. If we can reconvene at 11 o'clock, and then we'll go straight into the cross-examination.
Thank you.
So the inquiry is adjourned till 11 o'clock. Thank you, everybody. The inquiry is resumed. Mr. Grant, if you please carry on.
Thank you very much. Good morning, Mr. Daines.
Hello, sorry, hi, good morning, Mr. Grant.
I just want to start off, Mr. Daines, by asking you about the nature and extent of your involvement in dealing with this case.
Okay.
First of all, the site visits that took place in October 2019 and in January 2020, both of which were referred to within the delegated report. Were you the officer or one of the officers attending at those site visits?
I was, yes.
Second, the delegated report, we don't need to turn it up yet, but so far as that report is concerned, you were the author of that report, weren't you?
Yes, I was.
And it was signed by you on the 27th of January.
If that's what, yes, that sounds
I
right.
promise you that's right.
Okay.
And in terms of the purpose and function of that report, that is to record how a decision was made by a public body, i.e. the local authority.
Yes, I believe so.
And when you wrote your report, you understood, therefore, didn't you, the importance of putting into the report everything that you regarded as being relevant to the decision to issue enforcement notices?
Well, I mean, in relation, I suppose, to the policies that underpinned my assessment at that time, yes.
Yeah. I'll ask the question again. You understood the importance of putting into the report everything that you regarded as relevant to the decision to issue the notices.
I mean, I knew and I know that it's important to put relevant information into that report.
Yes. Well, is the answer yes?
Sorry, ask me the question again, please.
One last time, you understood the importance, didn't you, of putting into the report those matters that you regarded as being relevant to the decision to issue the notice?
Yes.
Thank you. And in terms of the matters that you regarded as being relevant, that specifically included expediency, and so don't worry, we're not going into that matter, but that specifically included, didn't it, matters that were relevant to the expediency consideration of issuing notices?
Yes, I mean, expediency is something that's considered when
Yeah.
serving notices.
Yeah. And you understand, don't you, that the statutory requirement when considering expediency is to have regard to the provisions of the development plan and any other material considerations?
Yes, I am aware of that.
And therefore it follows, doesn't it, I think as a logical sequence, Mr. Daines, that you included in your report that those development plan provisions and other material considerations which you considered to be relevant.
That were adopted at the time, yes.
And again, just following the chronology, the enforcement notices were issued the same day that the report was signed, on the 27th of January.
Okay,
Yeah.
yes.
And they were signed, weren't they, by Patrick O'Connor, who is the enforcement team leader, I think, or was.
That is correct, yes.
And the notices were issued based on your report, which he also countersigned, didn't he?
So he did countersign the report, yes.
Yeah. And just following forward in the chronology, we then get into the appeal process. And so far as the council's statement of case, again, can we assume, I take it, that you were the officer who responsible for drafting the council's statement of case?
Yes, I am. I was.
And so far as the proof of evidence, again, it was you, wasn't it, who assessed the various grounds of appeal and set out your analysis within the proof.
Yes.
And again, you included in your proof, didn't you, everything that you believed to be relevant for the inspector to consider?
Do you mean the proof and the addendum proof together?
I'm talking about your proof of evidence. When you wrote your proof of evidence, which was served 28 days before the inquiry started, you put in everything that you believed to be relevant for the inspector to consider.
I put in everything that I put in everything that I knew at that stage to be relevant.
We'll come on to other matters. Don't worry.
Okay.
And then after proofs of evidence, we get to the next stage before the start of the inquiry, which was the statement of common ground. And we have in the addendum evidence from Mr. Sutton, the exchange of emails, you've seen those, between the solicitor for the appellant and the solicitor for the counsel. And the solicitor for the counsel, Christine Stevenson, was taking instructions from you, wasn't she, in respect of the statement of common ground?
Yes, she was. Yes.
And so through each stage that we have just gone through before the start of the inquiry, so the delegated report, statement of case, proof of evidence, statement of common ground, you focused carefully, didn't you, on what you considered to be the relevant considerations to set out for the inspector?
Yes.
Yeah. And if in either the delegated report, for example, or the statement of case, you thought you'd missed anything that you wanted to say, you then had an opportunity, didn't you, when it came to proofs of evidence 28 days before the inquiry, to put that right?
I mean, I suppose the proofs of evidence was an opportunity to include information that hadn't been included previously. Yeah.
Good. That's by way of background. Now, next topic, please. The use of the units at the date that the notices were issued. So the use of the units at the date the notices were issued. And we have, don't we, Mr. Daines, some welcome common ground between the two parties, that at the time the notices were issued, the use was as service apartments. Yes?
Yes.
And can we now have a look, please, in your delegated report, which we've got at Mr. Sutton's Appendix 7.
Okay, yes, I have it.
And I just want to look briefly with you, Mr. Daines, at the features or characteristics of that use that you identified during your site visits. And can we start off, please, at paragraph 5.2.1 of the report?
Okay, yes.
I'm not going to read it, every single line, and if there's anything I miss out that you want to add in, then by all means do so. You see there on the third line, you say there are a number of guests present who are staying on a short-term basis. Yeah? And then on the fifth line, you put in inverted commas, presumably because you're quoting what you've been told, that they're staying for the weekend or for a few days or for the holidays. It was confirmed to you that guests have a specific checkout time, that being confirmed by a cleaner. Yes?
Yes.
And as a matter of common sense, therefore, there was a cleaner on site at least one of your site visits.
Yes.
And there was also on site at least one of those site visits, wasn't there, a maintenance worker?
Yes, there was. Yes.
And you made the observation, having inspected, I don't know, did you inspect some or all of the units?
I inspected a number of the units. I inspected the entire building in terms of all the floors and several of the units.
So in terms of the units that you inspected, you made the observation that they corresponded in terms of facilities with the advertisements you'd seen on Airbnb. Yeah?
Yes, yes.
And you then, towards the end of 5.2.1, set out some of your observations in terms of services, and you refer to the use to the laundry room with 6 washing machines and bags of towels and linen. Yes?
Yes.
And then at paragraph 6.1, right at the end of paragraph 6.1, you refer to the cleaning service being provided, and then you add other services that are provided, broadband and toiletries. Yeah?
Yes.
And at 6.2, you provide the comment that the property is advertised on a nightly basis and it's marketed to the transient visitor tourist industry rather than the conventional housing market. Yeah?
Yes.
So those are the characteristics you identified on those site visits. And what I would like us to do together, please, as our next topic is having in mind the characteristics you noted to consider those against the list in Panayi that you relied on in your written evidence and in your evidence in chief. Yeah?
Okay.
And so far as Panayi, we can go, I think you've got the cancelled circular in your appendices, but we've got the section set out, haven't we, in your addendum proof of evidence at paragraph 3.24. So I wonder if you could open that, please. Are you there, Mr. Daines?
Almost. Sorry. Yes, I am now.
And just before we turn to those, the comparison against the Panayi characteristics was not something, was it, that you had set out either in your statement of case or in your proof of evidence, but you did so here in your addendum proof of evidence after we adjourned at the end of day 1 of the inquiry?
I had not included it before that, but I was and am familiar with the distinguishing features that it sets out, and was so at the time of writing that report.
Good. So you were familiar with it, but nonetheless hadn't addressed it up until your addendum in terms of analysis.
Well, I mean, in relation to the points I reference in my report, I mention in terms of like how things are paid, the level of servicing. I don't mention in terms of communal facilities, and so obviously I might not refer to it in name, but obviously I speak to some of the distinguishing features that it outlines.
And if we have a look then, please, at the list on 3.24 in your addendum.
Yes.
The first bullet point deals, doesn't it, with dormitories and or communal or shared facilities. And you understand the position, don't you, that the appellant points to the laundry room as being a communal or shared facility, yes?
I'm aware that the appellant points to that.
Yeah. Now, so far as the laundry room is concerned, you make some observations about that in your addendum, don't you, at paragraph 3.27.
Just bear with me one moment, please. Yes, I do.
And I just want to touch on some of those observations, please. But first of all, is there any signage that you saw which indicates that the laundry room is for use by staff only?
I did not see any signage, no, but there were other sort of indications that it was only to be used by staff.
Mr. Daines,
Yes.
I told you we're going to go through the points you rely on in paragraph 3.27.
Okay.
So answer the question, please. Was there any signage that you saw that indicated that the laundry room was for use by staff only?
No.
So far as your observation that the room lacked material finishes such as paintwork, contemporary cabinets, or other materials found through the apartments themselves, the room that we're talking about is a laundry room, isn't it?
Yes.
Yes.
So.
And is it your position, just so that we understand it, is it your position that if guests were allowed access into the laundry room, that the laundry room you would expect to have a high standard of contemporary cabinets? Is that what you're saying?
I'm saying that in terms of legibility, there was nothing that suggested to me that laundry room was to be used or could be used by guests.
Was there anything to suggest that the laundry room could not be used by guests? Anything you could point to?
Could you ask me that again?
Yeah, is there anything you can point to that would say to a guest, I'm not allowed in there?
I mean, the fact that the room was in use and was full of dirty linen would make me think that if I had seen that, or if a guest had seen that, that they couldn't use that room because it was being used by the cleaner on site.
Yeah, but it's not. You heard evidence from Mr. Sutton, didn't you, of times where he's been there where it's not been used. You wouldn't expect it to be in use 24 hours a day, round the clock, would you, by staff?
I mean, there are a lot of units there. I don't know how often it is used, but I would suspect that it's probably in use quite a lot.
Is there anything that I'm going to ask you one more time, anything that you can point to, other than your own assumptions, Mr. Daines, anything that you can point to that you saw or heard that identifies that guests are not allowed to use the laundry room?
No, I didn't see anything that identified that they couldn't, but what I would say is it was the absence of anything saying that they could is what I observed.
It is, if the laundry room had a lock on it, that is something you would have noted and told us about, isn't it?
Because the room was in use by the cleaner at the time, obviously you can see from my site note images that the door was covered in sheets because the room was fully used. So I did not observe that at the time. That's not to say that there wasn't a lock there, but it was obscured from my view.
Sir, can I again invite you at the site visit to have a look at whether or not the room is lockable?
Can I just come back as well on this? You were interrupted, Mr. Daines, when you said put indications, staff only. Have you covered those in the way the room was used with the laundry on the floor, or have you got other indications that it's staff only?
So my indications that it was staff only is that there was no indication that there was that it was to be used by guests. So, you know, whereas the site has signage to direct guests to the various rooms and other parts of the building, there is no signage anywhere within the building to direct them to that laundry room. So on the point of signage, my point was that there is no signage, period.
Right. Thank you very much. Thank you.
Back to the list, please, at 3.24.
Yes, okay.
The second bullet point on the list refers, doesn't it, to sorry, sir, would you just give me one moment, please?
Yes.
The use of premises in accommodating specific categories of people. You see that?
Yes.
For example, the young or the homeless.
Yes.
Yeah. Now, you made the observation, didn't you, at your site visit or visits, that the units are marketed to tourists and visitors.
Yes, I mean,
Yeah.
this is in my report you're talking about.
Yeah.
Yes, I do say that.
And so far as the tourists, visitors to London, they are a category of people, aren't they?
I mean, I would say, I mean, no. I mean, yes, if you were thinking that you could categorize in any respect. I mean, they're certainly not in relation to Vinyai in terms of the examples it gives in terms of young or homeless. I think if you're including the type that you refer to, I do not believe that to be the case.
Yeah. The young or the homeless are specifically provided as examples, aren't they?
They are, yes.
Yes. That's not a closed list, which suggests that the categories of people applicable are the young or the homeless, is it?
No, it's not. But I suppose the young or the homeless suggests an individual that might be in a vulnerable state.
Well, where do you find that anywhere? In any of the authorities that you've produced, where do you find that what is meant in Panayi is that the use of premises in accommodating specific categories of vulnerable people? Where does it say that that's how that should be read?
Well, I don't know. It might say that somewhere, but I don't. If it does, I don't know where it is.
No, you're adding in, aren't you, to Panayi, your own interpretation of what that means. You're inviting the inspector, aren't you, Mr. Daines, to add in the word vulnerable to the second bullet point, aren't you?
No, I'm not inviting him to do that. I wouldn't do such a thing. I'm just saying, looking at it, I don't think that the examples it gives includes the type that you refer to.
But those are examples, aren't they, Mr. Daines? Yes or no?
What examples?
They are given as examples, aren't they? Yes or no?
They are given as examples, yes.
Yeah. It is not a closed list, is it? Yes or no?
It's not a closed list, no.
No. And the inspector is entitled, isn't he, to reach the view that tourists or visitors are a specific category of people, isn't he?
He is.
Yeah. And both the local Hackney plan and the London plan, we'll come on to this in due course, specifically identify, don't they, accommodation for visitors.
I mean, if you could take me to that specific point, I could check.
Mr. Daines, you've been in evidence in chief this morning, looking at the local plan policy for visitor accommodation, LP25,
LP25,
and
yes.
E10, the London plan policy for visitor accommodation, and you're asking me to take you to it to show you where those the plan refers to visitor accommodation?
I mean, now that I realise what specific policies you're referring to, but yes, I did ask you to take me to them, but
Right.
I do not believe you need to do that anymore.
Third bullet, whether the premises are serviced and or supervised. Do you see that?
Yes, I do see that.
And those are given, don't they, as the servicing and supervision as alternatives and or.
Yes.
Yeah. And in your analysis at 3.25, you go through these bullet points, don't you, one by one?
Mm-hmm.
Yeah. And the one matter that you leave out from your analysis is the question of services, isn't it?
I say no supervision was evident or witnessed.
Yeah. Where in that analysis do you talk about the provision of services?
I do not mention the word services, but I do refer to the point as a whole. So obviously, read as a whole, I refer to all the other areas where they are not, where there is a difference.
Right. Where do you set out, other than the list of Panayi, in your entire analysis that follows? Because I'm going to suggest, Mr. Daines, that your approach throughout is less than balanced. Where do you set out the provision of services when you are considering the Panayi characteristics?
I'm sorry, I don't
Yeah,
understand.
where do you refer in any of this analysis? Where do you refer to the provision of services?
In relation to, I mean, I would have to look through the document to see where I refer to it.
Right. You don't, do you?
I mean, I don't refer to it in 3.25.
Right. And so far as those services are concerned, again, going back to the delegated report, you acknowledge, don't you, the provision of toiletries, broadband, cleaning. You acknowledge a maintenance worker on site. So you accept, don't you, a significant variety of services that are provided within the premises.
Yes, I do accept that they're service departments.
Right. Next, please, whether the payment is on a nightly basis.
Mm-hmm.
And you've acknowledged, haven't you, that the in your delegated report that the payment is calculated on a nightly basis.
I mean, I don't have it in front of me. I'm looking at the addendum proof, but
Right. Go back to your delegated report then, 6.2. We were there 10 minutes ago.
I have a big folder of paperwork in front of me, so you'll have to bear with me.
Right. Just let me know, Mr. Daines, once you've got it.
Certainly.
It's the line we read out before, where you said that it advertises the property on a nightly basis. Do you recall that?
Yes, I do.
Yeah.
Yes, advertise property on a nightly basis.
Yeah. And in your analysis of the Panayi characteristics at 3.25,
yeah,
you make the point there that payment is not made nightly, but in full prior to occupation. You see that?
This is in the report, sorry, you say?
No. In 3.25 of your addendum, the analysis of the Panayi characteristics.
Yes.
You say, don't you, that payment is not made nightly, but in full prior to occupation when booking?
Yes, I do.
Yeah. so far as the characteristic identified in Panayi, whether payment is on a nightly basis, is it seriously your argument, Mr. Daines, that means that payment has to be physically made each night or in respect of each night? Is that what you're saying? That each night the payment has to be physically made?
I say in 3.25 that payment is not made nightly, but in full prior to occupation when booking.
I know that's what you say. We just read it out. Are you saying that what Panayi means in the 5th bullet, where the payment is on a nightly basis, are you saying that what that means is that payment has to be physically made on a nightly basis?
Yes.
That's what you're saying.
Well, I mean, yes, that is what I'm saying.
Right. So when a local authority places somebody in a hostel, situation you'll be familiar with when and how that happens, aren't you?
Up to a point.
Yeah. When a local authority places somebody in a hostel, you don't seriously think, do you, that a local authority will pay the provider, will go and pay them every day, or telephone them every day, or send them a check every day? Is that how you think it works?
I think it can work like that. Yes. I mean, look, I don't know exactly how a local planning authority manages its nightly payments.
No. But Mr. Daines, if a local authority placed somebody in a hostel, for example, for 14 days, are you seriously telling the inspector that you believe that the local authority would then make 14 separate payments over 14 days?
I mean, I don't know what a local authority will do.
But it's nonsense, isn't it?
Go on, you can move on, please.
At 3.24, where you set out the sort of preamble for the Panayi characteristics, and Mr. Daines, what you say in the second line, quite correctly, it was found that the presence and use of some of the features below combined were sufficient to distinguish the use of the premises as that of a hostel. Do you see that?
I do say that, yes.
And again, Mr. Daines, I think just as a matter of common sense, that means that in the analysis, when considering whether or not a premises is in use of hostel, it doesn't need to satisfy each and every one of these bullet points in order to fall within the meaning, does it?
I mean, I would say as a minimum, it would need to accord with a majority of them.
Where does it say that in Panayi?
I don't know where it says that in Panayi.
No. Where have you pointed to anywhere in case law or anything else where it says that you need to meet a majority of the characteristics in order to fall within the meaning of hostel?
Yeah, I mean, I do not.
No. That's not what it says, is it? It says that you need to, where some of the features combine, that is sufficient to distinguish the use of the premises as that of a hostel.
Yeah, it does say the word sufficient, though. And I mean, I suppose there's a presence of, if I was to go through this entire list and look at what I would consider to be sufficient, which is what it does say, I would say that focusing on one word or two words from this entire list would not be sufficient in relation to establishing that it was a hostel over C1 serviced apartments.
We understand where the differences are between you and the appellant on the analysing the list, because we've just gone through them. But can we note, Mr. Daines, that you're not pursuing the point that in order to meet the Panayi test, if we can call it that, in order to meet that, you need to satisfy a majority of the characteristics?
It doesn't say the word majority.
Right. Finally, I think on this topic, the case of Westminster, please, which you have in your addendum at Appendix 12.
Yes, okay.
And in cross-examination of Mr. Sutton on Friday, and then in your evidence in chief this morning, the inspector was taken to the extract from the Commercial and Residential Property Development Company case in paragraph 6. Do you see that?
Yes.
Yeah. And just pausing there, when you included the Westminster case in your appendices, it was specifically included, wasn't it, to deal with a point about a mixed use between hostel and hotels. The purpose of including it, wasn't it? Paragraph 3.26 of your addendum.
Well, the purpose of including it was to highlight the differences between the two uses.
Yeah. And the point that was picked up on Friday and this morning was the reference to relatively basic and inexpensive. Do you see that?
Yes.
Now, in your analysis set out in your addendum, where there or in any of the other documents you've provided since and including your delegated report, where do you set out your analysis of whether or not the development is basic and inexpensive?
So in my addendum proof, I refer to the case law where that point is made.
Where?
In 3.26, when I refer to the case law itself.
3.26 of what? Of your addendum proof?
That's where I refer to the Westminster City Council. Is that?
No, I understand that. We've discussed that. Where do you say that in your analysis of whether or not the use falls within the meaning of hostel, where do you say anywhere that a relevant consideration is whether or not it is relatively basic and inexpensive?
I do not say that specifically, but as I refer to the case law, I am of the understanding that obviously then that is then the judgment of that and all of its contents are relevant in this case.
No, I'll just ask you one more time and then I'll move on.
Okay.
Where have you ever said before the oral evidence in this inquiry that you consider as part of the test to whether or not something is a hostel, that it should be relatively basic and inexpensive? Tell us where.
So if you just bear with me one moment, I'm just checking through my documents. In my report 5.21, obviously I do not use the word inexpensive or basic, but I do talk about some of the fixtures and fittings and the kitchens, and including the services that you would expect from a non-basic use.
Mr. Daines,
Yes.
basic and inexpensive. Where anywhere, this is the last time I'm going to ask it, where anywhere have you identified in any of the written material submitted to this inquiry before or since the issue of the notice, where have you identified that part of the test is whether or not it is relatively basic and inexpensive? Where? Or is the answer nowhere?
So I have not included those words.
Right. And if you have a look, please, at paragraph 6 in Westminster.
Yes, okay.
The very beginning of paragraph 6 tells us, doesn't it, that in Panayi, account was taken of the earlier decision of commercial and residential property development.
Okay.
Doesn't it?
Yes.
Yes. And the list that you have set out from Panayi, that has not included, has it, the reference to the premises being relatively basic and inexpensive?
Again, it does not, but it does refer to the case law that where that is included.
What refers to the case law?
My addendum proof.
No, Mr. Daines. Paragraph 6
Yes.
tells us, doesn't it, that in Panayi, account was taken of the earlier case in commercial and residential property development. Correct?
Yes, it does.
And it's Panayi that gives rise to the list of characteristics that we've been talking about. Correct?
Okay.
And in Panayi, whether or not accommodation was basic and inexpensive was not part of the list, was it?
I said it's not part of the list in my addendum proof. Is that what you're asking me?
In Panayi, which you've read the relevant section set out in the cancelled circular, and you've set it out again, haven't you, in your addendum proof? Yeah?
Yes.
That list of bullet points that we've gone through already
Yes.
does not include, does it, whether or not accommodation is relatively basic and inexpensive?
It does not, though.
No. So before we look at some photos, I want to ask you this one time, please, Mr. Daines. Let's hope we can keep it simple. When did the reliance on whether accommodation is basic and inexpensive, when did that first become part of your case?
I mean, that's become part of my case. I mean, as I first referenced the case law in my addendum proof.
It became part of your case during cross-examination of Mr. Sutton, didn't it?
No, I don't believe so.
You had never, in the multiple opportunities we've been through, at the various stages of your involvement, you have never set out, have you, that in order to consider whether or not something is a hostel, you need to consider whether it's basic and inexpensive, have you?
I mean, I believed that I could reference the case law that would include those, and I did not need to spell out every point that's detailed within those judgments.
Mr. Daines, do you remember the sequence of questions I asked you at the beginning of cross-examination about the material that you included in your report, your statement of case, and your proof of evidence? Do you remember?
Yes.
And you acknowledged, didn't you, that in that sequence of documents, you included all matters that you regarded as being relevant for the inspector to have regard to.
I did say that.
Yeah. Right, now can we have a look, please, at Mr. Sutton's appendices, please, in particular Appendix 3.
Yes. Yes.
I'm sorry, you're going to have to bear with me because I have to find it myself.
That's okay.
Got it. Thank you. Appendix 3, photographs. You see those?
I do, yes.
Now, I'm going to, the inspector wouldn't thank me, I'm sure, for exchanging adjectives with you about what we do or don't see in photographs and how we regard it. But what we see in the photographs, on the first photograph, do you see of the kitchen facilities?
Yes.
I mean, if we disagree, we disagree, and the inspector can make a judgment. But those, on any sensible analysis, those are basic kitchen facilities, aren't they?
In relation to the image in front of me, you mean?
Yeah, what we can see here, the inspector will see on his site visit, but it's basic kitchen facilities, isn't it?
I mean, they are kitchen facilities, yes.
Yeah. And where you said in your evidence in chief, I think in terms of, you're talking about the microwave, you said it's a high-end microwave. What leads you to say that as a matter of interest?
I mean, so obviously we're currently looking at just one image, but obviously, I mean, if we look at either the my site visit photographs or even the advertisements on Airbnb, which are my appendices, obviously that paints a very different picture of what the standards of these apartments are like. So I appreciate this one image may appear the way you are suggesting, but obviously if you look at others, and certainly at the time of my visits, I would say they were not basic. And I think even some of the adverts have images of high quality microwaves.
Are you,
whatever term I use, I forget exactly.
Are you saying that the photographs we see at Appendix 3 are not characteristics of the units the inspector is going to see on his site visit?
I would say they're not characteristic of what I witnessed during my site visits.
Not characteristic. And tell us, please, what's not characteristic? What do you say is misleading about these photographs?
I suppose they lack some of the sort of what's the word? Some of the flourishes that I had witnessed on site.
Some of the flourishes. Okay, well, let's have a look at your site visit report again. It's Appendix 7.
Appendix 7.
This is your site visit, your delegated report where you set out things that you saw at your site visits.
Oh, do you mean number 5? Sorry, is 5 what you mean?
No, your delegated report.
Yeah. Oh, yes.
Third time we've been there. It's at Mr. Sutton's Appendix 7.
Sorry, I thought you meant my site visit notes. Yes. Okay. My delegated report. Yes.
Right. You set out, don't you, there, what you saw at your site visit, 2 site visits.
Yes, I do.
Between 5.21, 5.2.1 and 6.2, you set out what you observed. And what are the flourishes that you point us to in those that report that you're referring to?
Well, I mean, I would say those flourishes are evident from the site visit photos and also from the advertisements on Airbnb, which I do refer to in the report.
Just tell us what the flourishes are. Give us an example of one of the flourishes.
So you have leather couches, you have mood lighting, you have different sort of like linen, more sort of exotic colours. You have pictures on the walls. You have just there is even an image of a young lady sort of presenting a kitchen in one of them. Not that I would say that as a flourish, but
no. Yeah, we'll let the inspector take a view on that. The greater that you say is the quality that's being provided, we'll come on to this in due course, but the greater you say is the quality of the accommodation that's being provided, so the greater the weight that the inspector should give to the quality of provision as a material consideration in respect of ground A. Agree or disagree?
No, I disagree. I'm saying that they're not inexpensive, and that is the point that I'm trying to make here.
You said in your evidence in chief, high quality, and you just reeled off what you regard as being flourishes, and you've referred to high quality in cross-examination as well. Do you agree or disagree with the proposition that the higher the quality of the serviced apartments, the more weight in respect of ground A the inspector should give to the quality of the accommodation as a material consideration?
How much weighting I should give? I don't think much weight should be given to it, if any at all.
I'm going to ask you one more time.
Okay, sorry, please do. Could you maybe rephrase it a little bit? Because I must admit I'm not.
Right, you understand, don't you, that the appellant puts forward the quality of the serviced accommodation as a material consideration in favour of the development as part of ground A. Do you understand that?
Okay, yes, I do.
Yes. And in terms of the quality that is provided, do you agree or disagree that the greater the quality, the more weight it attracts as a material consideration?
I mean, I think it may have more weight, but I would say that rating would certainly not outweigh any of the other points within the various policies in relation to ground A.
I'm not asking you to do an overall balance. We'll come to that later. Just answer the question and we'll move quicker. Agree or disagree with the proposition I suggested that the greater the quality, the more weight as a material consideration?
I mean, I think it's difficult to say. I would say it would hold. I mean, if you're saying I can't do a balancing or I can't assess the weighting, I suppose I do not know. I would say it has limited, if any, weight.
I'm going to move on. We might have to come back to it later, though. So far as your point about cost, please, where have you set out in your report, your statement of case, your proof, or anywhere at all, where have you set out your evidence as to cost, by which I mean comparative evidence that the inspector can rely on. Where have you set that out?
As in to quantify the cost of the accommodation, is that of the serviced?
Where have you set out
apartments?
your analysis of costs against comparative costs to reach the conclusion that it is not inexpensive? Where have you done that?
I have not.
No. And you know, don't you, from Mr. Sutton's proof of evidence, and he went through it, I think, in the very beginning of his evidence in chief, that he has extensive experience of dealing with serviced accommodation and hotels in London.
Okay.
Recall that?
Okay, I don't recall that, but yes, okay.
Yeah. And as somebody, as an experienced planning consultant who has extensive experience of dealing with serviced accommodation and hotels in London, you would expect, wouldn't you, him to have a good understanding of whether a particular offering is expensive or inexpensive of its type in London, wouldn't you?
I mean, he may or may not. I suppose I do not know. I do not know.
Mr. Daines, you can agree if you agree with something, all right?
I'm aware of that.
Let me ask once more and then I'll move on. As somebody who has extensive experience of dealing with serviced accommodation hotels in London, as Mr. Sutton set out, you don't challenge that he's not making that up. You accept that that's the case, yes?
If that's the case, okay.
Yep.
Accept that.
As somebody with extensive experience in that sector, you would expect him to have a good understanding, wouldn't you, of whether or not something is expensive or inexpensive of its type in London.
I mean, again, I appreciate you might want me to answer this differently, but I cannot comment on whether he is in a position to do that or not. I mean, he may well be, he may not. I do not know.
Right. Next topic, please. The lawful use as hostel. Lawful use as hostel. Can we take as our starting point, Mr. Daines, and at least you'll agree with me on this, I hope, as our starting point, that use of hostel on the upper floors was granted planning permission in 1994. That's a good starting point.
I think following submission of the evidence from Friday, I think on the balance of probability, yes.
Right, you're jumping ahead. Just answer the question. Planning
Yes.
permission was granted in 1994 for the use as hostel, correct?
Yes, planning permission was granted in 1994.
Yeah. And then the second question, which is I think the one that you were jumping ahead to, the second question, you accept as a council, don't you, that 1994 planning permission was implemented?
On the balance of probability, yes.
Right, so the answer is yes, isn't it?
I said yes, I think, yes.
Yeah, good. And again, just uncontroversial common ground between us, I think. There has been no subsequent grant of planning permission for a change of use on the upper floors. Correct?
That's correct, yes.
And no subsequent grant of a certificate for other lawful use on the upper floors, correct?
Yes, that's correct.
So can we then look together, please, at the factors, Mr. Daines, that you've identified for your argument that there was a change to C3 residential use?
Okay.
Yes, do you follow that?
Yes, I do. Yes.
Good. So there are 5 or 6 factors, and I just want to touch on each, please. First, council tax. Now, so far as council tax is concerned, you rely, don't you, on the information provided by the council tax department that you set out at Appendix 17.
Yes, that's correct.
And we know from that, don't we, that the council tax was paid by Timings Limited.
Yes, I mean, which could you just, I just would like to have it in front of me when you're asking me those questions.
Appendix 17, your Appendix 17.
Yes, okay.
Presumably you've seen this email lots of times, haven't you?
I've certainly looked at it more than once.
Yeah. So we know, don't we, that the council tax for the block was paid by Timings Limited. It's set out in the 3rd paragraph.
Mm-hmm.
Yes?
Yes.
And the point that you principally make on council tax, as I understand it, is that if the use was continuing as a hostel, you would expect that business rates would be paid rather than council tax, correct?
I mean, so I would not expect there to be council tax records from 2007. No, I would not expect that. And yes, I would expect there to be business rates.
Yeah, good. So I mean, you can agree with me if you agree with me. So the answer is yes.
Yes, I mean, I did say yes to you. So as far as I know, I'm doing that.
Yeah. And you understand the point made by Mr. Sutton on Friday, and it was referred to by my learned friend in your examination in chief this morning, that just as a matter of fact, once the parties agree that the use was as serviced apartments, it was still council tax that was being paid, not business rates. Do you agree? As a matter of fact.
The council tax is being paid recently, you mean?
Yeah. At the time when you accept that the use was as serviced apartments,
Yes.
council tax was being paid, not business rates. Correct?
Yes, that is correct.
And in your evidence in chief, you said that the fact that it is C1, but council tax is being paid, does not tell me it's not C1. You recall saying that?
When did I say that, sorry?
In your evidence in chief this morning.
Okay, that's what I said, yes.
Yeah. And if your argument as a matter of principle was correct, if your argument was correct about what you can infer from the paying of council tax, are you following me so far?
Yes, I'm following
If
you.
your argument was correct about what you can infer from the payment of council tax, then it would follow, wouldn't it, that when the property was in use as serviced apartments, business rates would be paid.
Well, business rates should be paid instead of council tax, you're saying? Yes.
Yes, agree?
Yes, I agree.
Good. Okay. So let's move on then from council tax. Next, please, we'll go through the strands. You understand the strands that you're relying on? You went through them earlier on today.
Yes, I understand.
The email from Mr. Hakimi, which we've got at your Appendix 18. So if you just turn over the page, you'll come to it.
Mm-hmm. Yes, I have it, thank you.
Now, so far as Mr. Hakimi is concerned, you heard evidence from Mr. Sutton on Friday, and I think, in fact, on day one of the inquiry, that Mr. Hakimi is neither an employee nor a director of the company that owned the site. Do you remember that?
I do recall that, yes.
And I think he said, didn't he, that he was he worked for the managing agents. Do you recall that?
I do recall that.
Yeah. And there may not be too much turning on this, but where you say in your proof of evidence, when you're talking about Mr. Hakimi's email, I'll turn it up because I understand why you want to go to documents and not just rely on me telling you what they say. In your proof of evidence,
Yes.
where you talk about Mr. Hakimi's email, it's at paragraph 7.20. Do you see it? I don't think it's paginated, actually, the proof, but paragraph 7.20.
Yes, I do see it.
And you say there that Mr. Hakimi has a legal interest in the site,
Mm-hmm.
which seems to have been based on information you've been given by Council Tax Department. Yeah?
Mm-hmm.
And the information you've been given by Council Tax Department is what we can see at Appendix 17.
18, yes.
Yeah?
No, 17, yes, you're right, yes.
Yeah. And what the Council Tax Department say to you in the penultimate paragraph is that you got emails from Mr. Hakimi's personal email account regarding matters for Timings Limited. Do you see that?
I do see that, yes.
And in the next paragraph, it says he writes in as the managing agent for Metro Property Group.
Mm-hmm.
Yeah. So nowhere was it saying, and I don't think it's really the point you're pursuing, Mr. Daines, but nowhere is it suggested, is it, that Mr. Hakimi has a legal interest, as you put it, in the appeal site or sites?
Well, I mean, again, the Council Tax Department believe it's his company, Mr. Payman Hakimi's company.
Well, you provide what you've been provided by the Council Tax Department is at Appendix 17, isn't it?
Yes, that's right.
Yeah, and they've told you that they believe it's Mr. Hakimi's company, and that is based, isn't it, on what they then set out, which is that they have emails from his personal email account regarding matters for Timings Limited.
I mean, that's what they say in this email, yes.
No. Have you ever done any company searches or anything of the like to establish whether or not he's got a legal interest?
I mean, obviously, because the company is based in the Isle of Man, it's that wasn't as easy to get hold of. I am aware that he is more than a managing agent for Metro Property Group, and that he's a managing director.
Yeah, of Metro Property Group.
Yeah.
They are not the owners of the site, are they?
No, they're not.
And are you content, Mr. Daines, to accept what Mr. Sutton has told the inspector, which is that Mr. Hakimi is not an employee or a director of the company, but is a managing agent? Are you happy to accept that?
I mean, I mean, this email doesn't state otherwise. So yes.
Oh, good. And at the time of the email that he was writing, that was in. I
mean, if I may, sorry, on that previous point, but I do not know.
At the time of the email that he was writing in January 2020.
Yes.
Yeah.
Yes.
He was rejecting, wasn't he, the suggestion that there had been a change of use to C1.
Yes, he was.
And he gave an account, didn't he, which was inconsistent with the use of service apartments. Correct?
Yeah, I mean, his account suggests C3 use.
Yeah. And we know, don't we, in January 2020, that that is incorrect, don't we?
In January 2020, yes.
Yeah. So
Well,
we know.
we believe it was C1 use.
No, I get that. I mean, all parties agree, don't they, that in January 2020, the use was of service apartments, don't they?
Yes.
We went through that earlier. And Mr. Hakimi was giving an account here, which was inconsistent with what both parties agree was the use in January 2020. Agree?
Yes.
Yes. And therefore, do you agree with me that the inspector should not regard Mr. Hakimi's email in January 2020 as a reliable provider of information?
No, I believe it still to be a reliable piece of information in relation due to Mr. Hakimi's long-standing involvement with the site.
But Mr. Daines, he was saying in this email to you, wasn't he, that the use is not as service apartments, wasn't he?
Yeah, he was saying the use was not Class C1.
Yeah, but everything he said in that email was inconsistent with use of service apartments, wasn't it? You just accepted that 2 minutes ago.
Yeah, I think this shows that I appreciate when this email was sent, but it's my understanding that this shows that there are questions over the use and that it suggests that there has been C3 use at the site.
Mr. Daines.
And sorry if I may, and that Mr. Hakimi does not believe that the uses on site falls under Class C1.
Mr. Daines.
Yes.
Mr. Hakimi was saying in this email that the use in January 2020 was not as serviced apartments. That was the effect of it, correct?
I mean, he doesn't. I don't think he uses the term serviced apartments. He refers to hotels, boarding houses, and guest houses.
Yeah, but you've agreed twice now that the account he gave in the email was inconsistent with the use of serviced apartments, haven't you?
I mean, I say, yeah, him saying that the use by our tenants and the lettings is not consistent with C1 use.
Yeah, and your position is, the council's position, is that at the time he was writing this email, the use was as serviced apartments, correct?
Sorry, apologies, Mr. Grant. Can you say that one more time?
Yeah, the council's position, as put forward by you, is that at the time of this email in January 2020, the use was as serviced apartments.
I mean, at the time serving of the notice, yes.
Well, the notice was served 12 days later, wasn't it?
Yes, it was.
Yeah, I mean, Mr. Daines, try and be straightforward where you can. Are you suggesting that there was or may have been some material change between the 15th of January and the 27th of January?
No, I'm not necessarily saying
Right.
that. I'm just referring to the dates. You're asking me when the council alleged C1 use, and I'm saying that would be the date of the notice.
Right. Is it the council's case that that at around the 15th of January 2020, there would also have been use of service apartments?
Yes.
Yes. Right. So, at the time that Mr. Hakimi was writing this email, he was claiming that the apartments were used in a way that the council say is not correct. Agree?
I I mean, again, he doesn't refer to any particular unit, but yes, some of the points that he refers to, we would not say is consistent with C1 use.
Yeah. And the appellant, you know, accepts also, doesn't he? The appellant company accepts also that the use at this time was as serviced apartments, correct?
Yes.
Yes. So therefore, what Mr. Hakimi was saying in his email on the 15th of January 2020 was not correct, was it?
I mean, him alleging that these uses is not class C1. I mean.
Yeah, Mr. Daines, you can't seriously, can you, be saying to the inspector that he should regard this email as being reliable when you reject the fundamental point being made by the author?
I mean, I think this email is reliable in so much as we have someone who we know has an interest in the property and has done for many, many years. Although on one hand saying that the use at that time is not C1, also referring to other elements, i.e. the tenants and the lettings. But yes, I do accept that he refers to uses ongoing at the site, and he does not believe that falls under Class C1.
Right, let me move on. Next plank, please, of your case. The electoral roll.
Yes.
Now, so far as the electoral roll evidence is concerned, one thing that doesn't tell us is when somebody was registered, does it?
Sorry, bear with me a moment. Could you tell me which document, like where, what?
Okay. You've got it in your addendum proof.
Yes.
AP4.
It's wonderful. Yes, thank you. So please, Mr. what was your question?
Right. The question is, one thing that the electoral roll evidence doesn't tell us is when somebody was registered at a particular address. This material we got here.
The material in front of us, it's in the inquiry, does not state that. No.
No. And you understand, don't you, that the appellant's position is that there was a period of time when the units were being let on an AST and that the tenants under the AST were subletting. You've heard that position and you understand the way in which it's put.
Yes, I have, yes.
And so far as the electoral roll position is concerned, when somebody is registering at an address, yes?
Yes.
Follow me. When somebody is registering at an address, it is a matter for the individual, isn't it, as to whether or not they put down the address where they have an assured short hold tenancy agreement, isn't it?
I'm sorry, I don't understand.
It is a matter for the individual who is registering, who benefits from an assured short hold tenancy agreement,
Right.
whether they put down that address, whether they sublet it or not.
Yes.
Okay. Next, please. 2013. So we're on point 4. So we've dealt with council tax, Mr. Hakimi's email, and electoral rolls. Point 4 is the 2013 application forms. And you went to them in chief, but we'll go to them again, Mr. Daines. So we have them, don't we? It's, I think, Appendix 14 and Appendix 15 in your original appendices.
Yes, okay.
And let's start with Appendix 14. The first point to make, as you were quite rightly asked about in chief, is that this has been filled out by the architects acting on behalf of the landowner, or the applicant. Yeah.
Mm-hmm. Yes.
And if we go, please, to box 18.
Yes, okay.
We can see, can't we, under the market housing dash existing, there are a series of available options
Yes.
to fill in. Do you see that?
Yes, I do.
And one of those options, the second down on the list, is flat stroke maisonettes, isn't it?
Yes.
And if an apartment was in use as a C3 residential unit,
Mm-hmm.
you would expect that, wouldn't you, to fall within the description flat stroke maisonette?
Perhaps you would. I think you could use either. But I would say, obviously, that within that same section, it does refer to the total existing residential units. And so, obviously, it still refers to them as 28.
No, but I think that the number's not an issue, is it? Because you accept that there was the consent in 1994 was amended to 28 units, wasn't it?
Sure. I don't refer to the number. I'm talking about the term residential units.
No, I understand that. But let's look at the breakdown, please, in the box market housing dash existing.
Mm-hmm.
A really simple question, Mr. Daines. You would expect that if something was in use as a C3 residential unit, you would expect the box that would be ticked would be flat stroke maisonettes, wouldn't you?
I mean, yes. I think, someone could, and I think in this case have ticked houses, but yes, they could have also ticked flats.
Yeah. I'm not asking what they could or couldn't have done. I'm asking what you'd expect if that was the use, C3 residential.
If I was expecting C3 flats residential, C3 residential, what, sorry, if I was expecting what?
If the use was as C3 residential units, the box you would expect to be ticked here would be flats stroke maisonettes, wouldn't it?
Yes.
Yeah, right. Can we then move, please, to the 2013 site visits arising out of the applications?
Yes, okay.
And
which number is that?
I'm about to give it to you.
Thank you.
We have those at Appendix 12 and 13 in your appendices.
Okay, yes.
Okay. Now, starting with Appendix 12, and that is the delegated report for application 0069, you can see, can't you, the date of the visit, the 26th of February 2013. Yes?
Yes, I can.
And you've, with my learned friend in chief, you took us, I think, didn't you, to I'm just trying to find the sentence that he took you to within that report in terms of the use that was. All right. So far as this report is concerned, what we don't have the benefit, do we, of the site visit notes from the site visit of the 26th of February, correct?
I mean, if there were separate notes, then no. I mean, they would have been incorporated into this report.
Yeah, I mean, it's just a simple question. We don't have the benefit of site visit notes, do we?
Well, other than what's incorporated into this report, no.
No, good. And in terms of the site visit that was undertaken by the case officer Sadi Olukadana, we don't therefore have available to us, do we, the information as to the extent of that visit, what she saw, what units she went into, how many were accessible, do we?
No.
And if we look at the Appendix 13, which is a site visit in October of 2013, this is the Barry Coughlin report. Again, I think the same is true, isn't it? We don't have the benefit of any site visit notes to assist us, correct?
I mean, you're saying we don't have any site visit notes. Obviously, an officer would attend the site and then incorporate their findings into the report. So the site visit notes are contained within this report.
Yeah, we don't know. No, that's helpful. We don't know, do we? Therefore, which units he had access to, or the detail of what he saw, do we?
Well, he states that he would appear. It appears to be in use as residential on the upper floors. So the appearance, according to him, is that the use was as residential on the upper floors.
I understand that, but if somebody wanted to just understand and interrogate that, we don't know, do we, how many units he had access to, or the detail of what he saw, do we?
I mean, I guess he's summarised here. He hasn't gone into the specifics for each unit.
No, we've got no idea how many units, or if any, he was able to inspect internally, do we?
Right, but I mean, he has. Yeah, I mean, he hasn't said no residential use. I mean,
No.
I appreciate what you're saying. He doesn't specify, but again, considering he would summarise his findings here.
Yeah, is the answer yes? I'm going to ask you one more time, Mr. Daines.
So,
We do not have any information, do we, as to which, if any, units the author of the report was able to inspect internally?
he doesn't specify that, no.
No. And we don't know, do we, whether in respect of any units he did inspect internally, whether the person or the occupier that he saw was a tenant or a subtenant, do we?
I mean, again, he doesn't go into that detail.
No. And the same is true of the report that we saw a moment ago based on the site visit in February. Correct?
Yes. Yeah, they don't go into that level of detail. I mean, they would not go into that level of detail. So but yes.
Not criticising the officer. I'm just saying what we can
Sure.
gain from it.
I appreciate that.
Good. Next, please. And I think this may be the sixth and last plank that you rely on in this sort of sequence of arguments.
Okay.
It is the point that's made about the appellant evidence that's been provided and the retention of documents. Remember those questions you were asked this morning, tenancy agreements and rental income and so on?
Yes.
Yes. And again, just to be fair to you and to remind you of the context, Mr. Daines, you understand the way in which it's put by the appellant, which is that over a period of time, there were assured short-hold tenancies, but that the tenants were subletting on an Airbnb type arrangement, was the way it was put by Mr. Sutton.
Okay.
Do you recall that?
Yes.
Yeah. And if the appellant produce a tenancy agreement in those circumstances, the tenancy agreement would set out the agreement between the landlord and the head tenant, if I can put it that way. Yes?
Right, okay.
And if the head tenant was entering into their own subtenancy arrangements, that wouldn't be evidenced by the head tenancy agreement, would it?
That would not be evidence of...
Wouldn't be evidenced by the head tenancy agreement, would it?
Oh, I see. No.
And similarly, let's suppose, Mr. Daines, you were a landlord renting accommodation to me as your tenant.
Yes.
And I was paying you rent.
Yes.
But I was subletting property. Yes.
Mm-hmm.
The rental payment that I was making to you wouldn't tell us anything, would it, about what may or may not have been happening between me and my subtenants, would it?
No, it would not.
No.
Or it may not.
Good. Okay. Next topic, please. And this is the lawful use as C3 residential. Okay, lawful use as C3 residential. And just so that we're clear about it, and we can go all over the place in the documents for this, but let's just look in the statement of common ground for ease.
Okay.
And again, Mr. Daines, if you just tip me off when you've got there.
I will do.
And once you're there, perhaps you go to paragraph 8.
Okay, yeah, is that paragraph 8 is ground B? Is that what
Exactly. That's
yes,
exactly. Okay. And can you see there the second sentence? The parties do not agree as to the lawful use. The LPA says residential C3 use. Yes.
Yes.
So without having to go around the houses and all the documents, we agree, don't we, that your case, the council's case, is that C3 residential use is the lawful use. Yeah.
Yes.
And in order for the inspector to agree with you, the inspector would have to be satisfied, wouldn't he, that there was a 4-year period of continuous use in respect of each unit to
yes.
arrive at that conclusion. Yes?
Yes. Yes.
If the inspector is satisfied that the C3 residential use in respect of a particular unit had become lawful, then you agree, I think, that would amount to the fallback position in respect of ground A, to which we're going to come on to shortly.
Yes.
Yeah. And in terms of the notices themselves, you relied, didn't you, on the loss of residential units?
I do refer to the loss of residential units, yes.
Yeah. And if we have a look at the notices themselves, we can just go to one, because they all say the same in terms of the reasons for issuing the notice.
Certainly. Let me just bring that up. Yes, okay.
We can see in the second reason that's given on every notice that is, just to be clear, that is a notice which relates to the land set out in paragraph 2 of the notice. Yep, which is headed the land to which the notice relates. Do you see that?
I do, yes.
So I'm looking, for example, at flat 1, but it doesn't really matter which one you've got in front of you. Yeah. And in the second reason, we can see that the unauthorized material change of property to use within the C1 use class due to the loss of a residential dwelling is unacceptable in principle. Okay. Yeah.
Yes, I do see that.
So you're accepting, aren't you, there, that for the change of use, if we talk about flat 1, for the change of use that was taking place at flat 1, the consequence is the loss of a C3 residential dwelling, correct?
If it was C3 for 4 years, yes.
Yeah, which is your case. So on your case.
Yes.
Yeah.
Yes.
And I think that's just reinforced, isn't it, in the next sentence, which then refers to the loss of a residential unit. Yeah.
Yes.
And throughout, and I mean, I've written down about 8 references, but I may need to take you to none, Mr. Daines, hopefully.
Okay.
Throughout your written material, by which I mean delegated report, statement of case, proof of evidence, you refer consistently to the loss of 24 residential units, don't you?
I do refer to the loss of 24 residential units in that documentation, yes.
Yeah. And within your proof of evidence, your first proof, if we turn forward in the proof, please, to paragraph 7.49.
$7.49, did you say?
7.49, yes.
Yes, okay.
It's actually in the within the section on ground G, but we never mind that. It says here the cessation of the use as a service department.
Yes.
And compliance with the notice does not preclude the appellant from using each unit as their lawful use. Do you see that?
Yes.
And that's entirely consistent, isn't it, Mr. Daines, with the way in which the notices were framed and the way in which you've consistently referred to the loss of 24 residential units. Yeah?
I mean, again, our allegation is the loss of a material change of use to C1, and we believe the last known use was C3. Last known lawful use, sorry, excuse me.
Yeah, I understand that, but where you say at 7.49,
yes,
the appellant is not precluded from using each unit as their lawful use. Do you see that?
yes,
Which, on your case, the lawful use is C3 residential. Yes?
yes,
That is entirely consistent. This isn't a criticism, Mr. Daines. This is, it is entirely consistent with the way the notice was framed, where for each unit it refers to the loss of a residential unit, and the references, as we discussed a moment ago, throughout your written material to the loss of 24 residential units overall. correct?
Yes.
Um, good. Now we're going to move into ground A matters. So I'm really in your hands as to how you want me to proceed and when you want to take a break.
Well, I normally plan to break about 1 o'clock, but if this is a more convenient time, I'm happy to do it a little early and come back a bit early.
Well, it's really a question of whether I do ground A, maybe I suppose an hour-ish, and then I'm finished, maybe a bit less than that. But it's a question of whether we go all the way through now and then break, or whether we take the break now and do ground A in one chunk, I think.
I certainly won't go all the way through for an hour. We'd have to break for lunch before then. So I think if you would prefer to start it after the break, then I think that we'll break for lunch.
Okay.
All right.
Very much indeed.
So you've got about an hour after lunch. Would 1:30 be an acceptable time to come back?
Yes, so far as we're concerned.
All right, then what I'm going to do is adjourn the inquiry for lunch, and we'll resume at 1:30 p.m.
Thank you very much.
Thank you very much. Inquiry is adjourned. Thank you, everybody. The inquiry is now resumed. Mr. Grant, if you could carry on with your cross-examination, please.
Thank you very much indeed. Good afternoon, Mr. Daines.
Good afternoon, Mr. Grant.
Three discrete points I think we can take quite quickly, and then we'll go into ground A.
Okay.
So the three discrete points are, first of all, so far as laundry is concerned, and you must tell me if you just don't know the answer, but the laundry room includes tumble dryers as well as washing machines, doesn't it? Did you observe that, or are you not sure?
I know there were 6 units, if I recall off the top of my head, but I'm not sure of whether they were tumble dryers or not.
So can I invite you at the site visit just to have a look at that,
I
please?
just made a note.
Thank you. And so far as the individual units are concerned, again, if you don't know the answer, then say so. But there are some which contain washing machines, but not tumble dryers, aren't there?
Yeah. Again, I mean, I know that some have, are washing machines or washing machine tumble dryers. I don't know of which, but I know that some do. Yes.
No, let me just ask the question again. There are some rooms, if you don't know the answer, then say so. Some rooms that do contain washing machines, but don't contain tumble dryers.
I do not know.
Okay. Again, so can I ask you just to note that for the site visit, please? Second, and these second and third points really are tidying up points, I think. The second is in your addendum, please, if you can just take that up.
Yes, okay.
And can you turn to 3.2?
Yes.
Well, obviously, we're not going into implementation together. We don't need to in any detail at all. But can you do you accept that where you said at 3.2 that no case had been made by the appellant in terms of reliance on the 1994 permission until the submission of the proof of evidence? Do you accept now that that is incorrect?
I mean, so what I would say on that point, if I may, I mean, obviously not the 1994 permission, but specifically that planning permission is in South 3694 FP. What I was referring to, that actual reference, that planning permission is not mentioned in the grounds of appeal or the statement. Although I do appreciate that there is reference to it, I think, in separate correspondence. Yeah,
I mean, you've included in your own appendices, haven't you, a letter from the appellant's solicitor in February of 2021?
I have, yes.
Yeah.
Yes, that's the separate correspondence I refer to. Yes,
and that letter clearly relies on the 1994 hostile use, doesn't it?
It does refer to it, yes.
Yeah, and so far as, if we really had to go there, so far as grounds of appeal are concerned, if you turn up your original appendices, at appendix 4.
Yes.
In fact, it's a statement of case. I'm so sorry, that's my mistake. Statement of case is what I wanted to take you to. Can you turn up, please, the appellant statement of case?
Okay, yes, I have it in front of me.
Yeah, and you see there, don't you, at 5.5
Yes.
under ground B, the lawful use of the appeal premises has remained hostile. Do you see that?
I see that it says that, yes. But,
Yeah. And then if you look above at 5.3,
yes.
you see there references made to the letter dated the 2nd of February 2021 from Christine Hereward.
I do see that, but again, on both of those points, 5.5 and 5.3, it doesn't mention the specifically that planning permission. But yes, I do see that it refers to 5.3 refers to that letter on the 2nd of February, and then 5.5 has the word hostile.
Yeah, Mr. Daines, it's not a game. You knew, didn't you, that when reliance was placed on the previous hostile use, that was by virtue of the consent granted in 1994.
I mean, I certainly don't think this is a game.
Right. Good.
But again, you know, in relation to that point, I appreciate that there is reference to permission from 1984 prior to that, and it's mentioned specifically in that letter from the 2nd of February.
Yeah.
And I take that point.
Yeah. Good. Third, please. Again, in your addendum, this is the third of the discrete points. Can you turn to paragraph 3.18?
Yes, okay.
And the final sentence, Mr. Streeton at the outset on Friday made plain that this sentence was not how the council would put in their case, but I just want to be absolutely clear with you, please. Where you say at 3.18, if the residential C3 use has now ceased and service apartments are in use at the site, then the site would now be nil use. And as Mr. Streeton indicated on Friday morning, you accept that that's not the way in which you put it.
Yes, correct. Yes.
Good. And for the final crossing of I's and dotting of T's on the same point, therefore, where you say the same thing in the final sentence of 3.33.
I believe it's the same.
Yeah.
Is that correct?
Good. And the inspector can effectively ignore that, can't he?
Yes.
Yeah. Good. Thank you very much. Now into ground A. Can we start, please, by having a look at one of the enforcement notices? You can pick up any one you like. I'm going to look at flat one.
Mm-hmm.
And can we look, please, at the reasons for issuing the notice?
Yes.
And here we see set out the objections that the local authority had as recorded within the reasons. And we see at 4.2, we've been here already. Do you remember the loss of a residential dwelling is unacceptable?
Yes.
And then at 4.3,
yes,
we see a paragraph from which we can, I think, extract, can't we, two objections. The first is harm to the character and function of the area, and the second is significant adverse impacts on residential amenities. So as reflected in the three issues the inspector identified in his comments at the opening of the inquiry. Yes?
I'm sorry, I don't understand what you're asking me there.
We're identifying your objections to the development, okay,
yes.
as set out in the enforcement notices.
Yes.
Yes.
Those
So
are
paragraph
some-
4.2, loss of a residential dwelling. 4.3 identifies two matters, doesn't it? Firstly, harm to the character and function of the area. Do you see that? First sentence.
Yeah.
Secondly, in the second sentence, significant adverse impact on the residential amenities of neighbouring occupiers at fourth floor level. You see that?
Yes, I do see that. Yes.
Right. So I wanted to deal with each of those, please. And can we start with the harm to the character and function of the area?
Mhm.
And as our starting point, can I ask you to take to hand, please, your delegated report, which we have at Mr. Sutton's Appendix 7, and the Statement of Common Ground.
Okay, I have both the delegated report and the statement of common ground in front of me.
Thank you. And let's look, first of all, at the character and function of the area and what it actually is. And let's start in your delegated report at paragraph 1.1. See that?
Yes.
You make the very broad point here, don't you, within your site description, that the surrounding area is characterized by similar sized blocks with a mix of uses. You see that?
Yes.
And then for some more specific analysis, we can go to the Statement of Common Ground. And if we start, please, at paragraph 5.4.
Yes.
And really the final sentence is the one I want to draw your attention to. So this is within the section agreed matters between the appellant and the council. The character of the area surrounding the site is defined by the predominance of retail or commercial uses at ground floor and basement level, and a mixture of residential accommodation and offices above. Yeah.
Okay, yes.
And then at 5.9 over the page,
Yes.
this part of Hoxton and Shoreditch comprises a significant mix of commercial, residential and office uses.
Mm-hmm.
In the vicinity of the site, a number of hotels and visitor accommodation can be found, which are reflective of the diverse nature of Hoxton and its proximity to central London and key transport nodes. Yeah.
Yes, I see that.
That's all agreed. And then can you pick up Mr. Sutton's proof of evidence, please? And when you've got there, can you turn to page 9?
Page 9, sorry, did you say?
Page 9.
Yes.
The heading character of the area.
Yep.
And we see here some of the underlying information which underpins what was agreed in the Statement of Common Ground, so that at 3.10, you can see there, can't you, the list of hotels or serviced accommodation within 200 metres of the appeal site, and then a list that follows. Yeah.
Mm-hmm.
And I didn't, there are any of those that you disagree with or any others that you want to add to the list?
No, there aren't any that I would like to add to the list.
Yeah. And at 3.12, having identified that list of hotels or serviced accommodation within 200 metres, 3.12, Mr. Sutton makes the point, it's considered that hotel visitor accommodation, whilst not dominating the local area, is a visible and significant element of the local character, which is a matter I think that you agree within the Statement of Common Ground. Yeah.
I'd say that it's a part of the local character.
And can you then take up, please, the London plan?
Which point specifically, sorry?
Well, I was waiting for you to get the documents. Have you got it to hand?
I don't know. I have. Do you mean specifically a specific policy?
I was going to take you to, in the first instance, to policy SD4
Okay.
and to the glossary.
Bear with me one moment, please.
You have to let me have these, Mr. Grant.
I'll make sure those who are listening in from my team make sure that you have this, sir.
Thank you.
Sorry, I do understand that the other policies were sent over the weekend, so they are on their way somewhere.
Yes, I've checked my computer emails over lunch and I haven't got any, so I'm sorry about that.
So do you want us to pause, or are you happy for us to carry
No,
on?
I'm happy to go on if you can just make me understand the context of what you're asking your question.
Will do.
I'll be able
Thank
to
you.
pick it up.
So which policy, sorry?
So let's start in the glossary, please.
Okay. Do you have a page number for that? Oh, there we go. Sorry. Yeah. Okay.
I do. If you turn in particular to page 500.
Okay. Yes.
And can you see on page 500, this is within the glossary definitions section, there is a definition for the Central Activity Zone, or CAZ for short.
I do see that. Yes.
Yeah. And so we'll read out the whole paragraph with Mr. Daines, because you obviously don't have that in front of you.
I am familiar with what the Central Activity Zone is, if that's...
Thank you. That helps. Just the first two sentences then. The CAZ is the vibrant heart and globally iconic core of London. You see that, Mr. Daines?
I do. Yes.
And it contains a broad range of functions that have London-wide, national and international significance, including government, business, culture, research and education, retailing, tourism, transport and places of worship. Yeah.
Yes.
And can you turn to policy SD4, which is at page 70?
Yes.
And SD4 is the policy for the CAZ, isn't it?
Yes, it is.
And I think we're all agreed, aren't we, that the appeal building is within the CAZ, isn't it?
Yes. Yes, it is.
And if we, so far as SD4 is concerned, the policy identifies at A, the unique international, national and London-wide roles of the CAZ. Do you see that?
I do, yes.
Based on an agglomeration and rich mix of strategic functions and local uses.
Yes.
That should be promoted and enhanced.
Yes.
And then at capital E of the policy, the unique concentration and diversity of cultural, arts, entertainment, nighttime economy and tourism functions should be promoted and enhanced.
Yes, that's what it says.
And at H, the attractiveness and inclusiveness of the CAZ to residents, visitors and businesses should be enhanced. And then it refers to public realm improvements and so on. Yes?
Yes, yes, it says that.
And then in the supporting text, at 2.4.4, we see there the strategic functions of the CAZ as set out. It says including, but not necessarily limited to. Do you see that?
Yes.
And then at little j in the list,
Yes.
tourism facilities, including hotels and conference centres.
Yes.
And with SD4 ringing in our ears, can we then have a look, please, at policy E10, which is at page 273.
Yes.
And policy E10, we're going to come back to this in a few minutes, but policy E10 at F.
Yes.
Can you see there? It says within the CAS, strategically important serviced accommodation should be promoted in opportunity areas with smaller scale provision in other parts of the CAS. See that?
Yes.
So in other words, we'll come on to the next bit of the sentence in a minute. In other words, promoting the serviced accommodation both within and outside the opportunity areas. Yeah.
Yes.
And then the exception in F refers to non-opportunity areas where it says except wholly residential streets or predominantly residential neighbourhoods. See that?
Yes.
And I don't think any of us would say, would we? And we've just been through the same as common ground, that the vicinity of the appeal site is a wholly residential street or a predominantly residential neighbourhood.
Not wholly, no.
No.
I mean,
And so far as SD4 is concerned, can you go back to the statement of common ground?
yes, okay.
And turn to paragraph 7.
Yes.
So SD4, let's remind ourselves, is the CAS policy, and the appeal site lies within the CAS, and you are relying on an objection based on the harm to the character and function of the area, yes?
Yes.
And in the section under London Plan, in paragraph 7 of the Statement of Common Ground,
Yeah, yes.
you say, don't you, the council, the LPA considers only H8 to be relevant. Do you see that?
Yes, I do see that.
And following that, the appellant considers the following to be relevant, and then a list of policies that include SD4, correct?
Yes, it does state.
And this was a statement of ground, as you told us, common ground, as you told us earlier, where you were liaising with the council solicitor. Yeah.
Sorry, what was that a question?
Yes, you were liaising, weren't you, with the council solicitor of the content of the statement of common ground?
Yes.
Yeah. And you took the view then that so far as SD4 is concerned, it was not relevant to the inspector's consideration of the appeal, correct?
I mean, it does say the LPA considers only H8 to be relevant. I think that could have been better worded. I think that should have spoken more to weighting than relevance outright. But that is what the document says.
Yeah. Well, you in the discussions in relation to the statement of common ground weren't prepared to agree that the council and the appellant consider the following policies to be relevant. That's why it's worded in the way it is. Correct?
I'm sorry, say that. Apologies. Could you say that again, please?
Yeah. You weren't prepared to agree to wording in the statement of common ground which said the council and the appellant agree that SD4 and various other policies are relevant.
I mean, I know that the statement of common ground was agreed at the very last minute, and so obviously there perhaps wasn't a sufficient time to look at it in the level of detail which I would otherwise have liked to have. But yes, it does refer to not referring that it considers certain policies relevant only.
Are you looking to abandon the statement of common ground on day 3 of the inquiry?
No.
No. You understood, didn't you, when the statement of common ground was being considered, the significance of that document, didn't you?
Yes.
And you were party, weren't you? Because you were in discussions with Christine Stevenson, the borough solicitor. You were party to the backwards and forwards process to achieve an agreed document.
I was.
Yes. And you took the view and set it out in that document that SD4 was not relevant. Now, do you accept now on day 3 of the inquiry that SD4 is a relevant policy for the policy context of the Ground A appeal?
Well, in so much as it's part of the development plan and it's one policy or one section of a policy within it, then there is an element of weight which can be attached to it, but that obviously needs to be considered in relation to the development plans as a whole.
Yeah.
So what I'm not saying in the statement of common ground is that the development plan should be ignored. I'm certainly not saying that.
Should be what, sorry?
It should not be ignored, or that it's not, the development plan is not a consideration. I'm certainly not saying that.
Well, no, I'm not suggesting you were saying that, but what was being identified were the relevant policies in the development plan for the decision-making context in this case, weren't they?
Yes.
Yes. And so far as SD4 is concerned, do you now accept what you didn't accept at the time of the statement of common ground, which is that that is a relevant policy for the inspector to have regard to in the Ground A appeal?
I mean, yes. I mean, if I may, looking at some of these policies, I can see points in them which should be considered. For example, what you mentioned when you were asking me about these policies, about policy E10, specifically E10F, and you obviously asked me about wholly residential streets or predominantly residential neighbourhoods. There is also a further point on that about the intensification and provision of service accommodation should be resisted where this compromises local amenity or the balance of local land uses.
Yeah, we're dealing with land uses at the moment, aren't we?
Yeah, but
coming on to amenity, we're dealing with land uses at the moment. Do you remember I said to you that this topic is the character and function of the area?
Yes.
Yeah, right.
Yes.
So in terms of SD4, can we record, and I don't want to keep going about the same point, but can we record, please, that you accept now that SD4 is a relevant policy for the inspector's consideration of the Ground A appeal?
I mean, yes, I accept that in so much as I accept that all policies within the development plan are, should be considered.
Right. And in your delegated report, can we take that up again?
Yes, okay, I have it in front of me.
Where you say at paragraph 6.14,
Where I say where, sorry?
6.14.
Of my delegated report?
The proof, are you looking at the proof?
In the delegated report, it's Appendix 7 in Mr. Sutton's appendices.
Oh, right, I understand this.
I mean, do you mean 6.4 and not 6.14?
No, 6.14 in your delegated report.
Oh, sorry, yes, 6. Yes, okay, please.
Okay, can you see there in the second lines 2 to 3, you talk about incompatibility with surrounding residential land uses and therefore harm to the character and function of the area.
Yes, I do see that.
Yeah. So what I just want some help with from you, Mr. Dane, so that we can understand your position, is where in the delegated report do you set out your analysis of the harm to the character and function of the area?
Again, I do not. I mean, there is no reference to it specifically, but again, there is references to various policies where it would reference that.
Where is your analysis of the harm to the character and function of the area?
You've had that answer. That they just said there's no reference specifically to
No,
it.
good. Okay, thank you. And then can we go to your proof of evidence, please? You'll be very familiar with your proof, Mr. Daines. I dare say you've read it a number of times.
Okay, I'm looking at the proof.
Yeah, there is no analysis, is there, in your proof of the harm to the character and function of the area?
Again, there is no. I mean, I would have to look through the entire document to be certain. But looking through it, there is not a mention to it in the beginning of the document. But again, it does refer to. It does include my delegated report, and that obviously has the policies contained within, and obviously the policies contained within this proof too.
But, yeah, I'm not talking about just naming the policy and setting out the policies. There is no analysis to explain how or why you say that the development harms the character and function of the area, is there?
Again, I say that I know it refers to the policies where this is referenced, but it doesn't mention it specifically. No.
And we discussed, didn't we, by reference to the statement of common ground, the agreed character of the area, didn't we, a few moments ago?
I'm sorry, say that again, please, Mr. Grant.
Yeah, a few moments ago, we discussed by reference to the statement of common ground, the agreed character of the area, didn't we?
Yes, and I think that
Yes.
includes a mix of uses. I think
Yes.
it's something that we agreed with.
Yeah. And so far as the use of serviced apartments in this area, that is not at odds, is it, with the character of the area?
I mean, the level of that provision would be, and I suppose, and as would be the loss of residential uses and the level of that too. Considering the area, the character is defined by a mix of uses, and any change in that sort of makeup would affect the character.
We'll come on to loss of residential use. Just listen to the question, please.
Okay.
Right? The use as serviced apartments is
Yes.
not at odds, is it, with the character of the area as agreed in the statement of common ground?
No.
No. And so far as the function of the area, do you remember we went through the CAS and the strategic functions and so on? Do you recall that just a few moments ago?
I do, yes.
So the use of serviced apartments is not at odds, is it, with the function of the area?
No, it's
No.
not.
Good. Can we look, please, at residential amenity?
Yes, okay.
And again, just so that we understand, first of all, your position, we're going to do the delegated report and then proof exercise.
Mhm.
So can we start in the delegated report at paragraph 6.12?
Yes.
And what you say there is the transient nature of the occupation of the property may also lead to elevated levels of noise and disturbance. You see that?
Yes.
And then just to that's your analysis of the amenity issue, and we can take that, follow that forward, can't we, into the notices themselves?
Mhm.
Because as we saw before, the notices themselves refer to the impact on the residential amenity of neighbouring occupiers at 4th floor level.
Yes.
So just piecing that together, Mr. Daines, as I understand your position on amenity, it is your concern is the noise and impact, the noise and disturbance caused to the occupiers of the 4th floor, by which I think you mean the 4th floor of this building.
I mean, that is one of the consideration, yes, but that it would have, I was referring to more broadly a residential community, i.e. Neighbouring properties.
Neighbouring properties, right. So where you talked about noise and disturbance
Yes.
in the delegated report,
Yes.
go back to it again.
Yes.
6.12,
Yes.
elevated levels of noise and disturbance, yes?
Yes.
And then following through into the conclusions,
Yes.
and the conclusions are then are reflected in the reasons in the notice,
Mhm.
yes?
Reflected in the reason, yeah, they are, yes.
And the conclusion in respect of amenity
Yeah.
in the report refers to adverse impacts of the residential amenities of neighbouring occupiers. And then
Yes.
once that is taken forward into the enforcement notices,
Mhm.
that was further particularised, wasn't it, by presumably you together with your team leader, or by your team leader acting on his own?
What was the question, sorry?
When it got to the notices themselves,
Yeah.
the amenity was further particularised by you and or your team leader within the reason, wasn't it?
I mean, I have gone into more detail in the notice.
Yes, that's what I mean when I say particularised. So the detail that you provided in the notice is specific, isn't it, in identifying the concern, the residential amenities of neighbouring occupiers at 4th floor level.
I mean, that's what it says on the notice. But again, as you pointed out in relation to the conclusion of my report, I talk more broadly of residential communities of neighbouring occupiers.
Yes.
So that, obviously that doesn't preclude the 4th floor. But obviously the 4th floor, as I mentioned in the notice, is included in that.
Your team leader, who countersigned your delegated report,
Yes.
and then issued the enforcement notices the same day as the report was signed,
Right.
decided, didn't he, to take forward into the reasons for issuing that the amenity issue was in relation to the neighbouring occupiers at 4th floor level.
Are you suggesting only? I'm trying to understand what you're asking me, Mr. Grant.
When your team leader issued the notices,
Okay.
the amenity issue identified in the notices referred to the neighbouring occupiers at 4th floor level.
The notice does say that, yes.
Yes. So when your team leader was drafting the notices for issue, based on your report, which he countersigned, the amenity issue that he took forward was the impact on the fourth floor occupiers.
And again, I wrote this notice. My team leader would have, of course, signed it off.
Yeah. And when you wrote the notice then, signed off by your team leader, and you particularized the amenity harm,
Yes.
you said it was the harm to the neighbouring occupiers at fourth floor level, didn't you?
I have written that on the notice, yes.
Yes. Right. And then so far as the amenity issue is concerned, first of all, if you're being faithful, please, to the objections set out in the notice, the inspector should consider, when talking about noise and disturbance, what is the impact on the residents of the fourth floor of the building? Yes?
Yes.
And in considering that issue, if the inspector agrees with the council that the lawful use is C3 residential, then the question for the inspector is what is the level of noise and disturbance to those fourth floor occupiers compared to the level of noise and disturbance that would flow from the lawful use?
Yes, but again, I would say not solely on the occupants of the fourth floor of the building.
But that's what the notice said, isn't it?
But that's not what the delegated report says.
Yeah, but
It's all right, Mr. Grant. Can you please move on? You've made the point, and I've heard the council's point, so I've
thank you.
both sides.
And thank you, sir. And in terms of considering the noise and disturbance issue, it is relevant, isn't it, for the inspector to consider the local context, by which I mean, first of all, the nature of the area in which the building is located, correct?
Yes.
And it's on, isn't it, a street described, I think, in cross-examination of Mr. Sutton as a busy street with lots of nightlife, words to that effect.
If that's what Mr. Sutton said, okay.
But it was put to him and he agreed it.
It was put about the area, not the street, but I don't think it matters.
No. And at ground floor, there is a bar, isn't there, on the ground floor at this particular building?
I'm aware that there has been. I know that at the time of my site visits, the bar was not functioning.
Yeah, well, it is now. Do you know that or not?
I do not know that.
And we know, don't we, from the planning history that it's been there and functioning for many years, because we can see, can't we, from the files you disclosed at AP13, a series of applications relating to opening hours and so on over many years.
Yes.
Yeah. And so that is the immediate context. And so far as your point about transient visitors as against more transient residents, I should say, as opposed to more permanent residents. You heard Mr. Sutton say, didn't you, that his expectation in terms of deliveries to site, he gave examples, remember, Amazon and supermarkets and so on. His expectation is that permanent residents would receive more deliveries than people who are there on holiday or for the weekend. Agreed?
I do not agree with that, no. I mean, I think in terms of serviced apartments, you would have, if you are having services, cleaning coming, I don't know, any other things that might be delivered, I would expect there to be a greater level of movement and transience, not just of the guests, but people that are coming and going and the services that facilitate that use.
Yeah. Okay. Well, there'll be a cleaner coming and going, won't there? We know that. Agreed.
Yes, I've witnessed it on site. Yeah.
Yeah, and you'd expect, as you saw on a site visit, that there would be a maintenance worker there where required.
Yes.
Yes, and you would expect, wouldn't you, that where somebody lives somewhere as their home, in this day and age, they're likely to receive deliveries from Amazon and Tesco and so on, aren't they? That's how most people live these days.
I mean, perhaps. I
Yeah.
guess I can't comment on what people would or would not have delivered.
Those who live somewhere on a permanent basis are more likely, aren't they, to receive deliveries during the day than people who are staying somewhere on a short-term basis on holiday.
I mean, I appreciate you want me just to give you a simple answer. I mean, the truth is I don't know.
But it's a straightforward proposition, isn't it? I mean, I'm not going to stay on this point for ages, but it is a straightforward proposition, isn't it? That it is more likely, Mr. Daines, that a permanent resident will receive more deliveries than a holiday maker.
Again, if you believe so, but again, I do not know.
So we'll record that you're not able to answer that question.
Well, I believe I have answered the question, but yes.
Well, what's your answer?
Well, I said I believe that based on the level of services and the services to facilitate the use, that you would see a lot of movement that would have immunity impacts that you wouldn't have otherwise.
Right, we've talked about a cleaner and a maintenance worker, and I was asking about deliveries.
Sure, I appreciate that, but I'm saying that there could be others. But I think your ultimate point was about the level of that as a comparison. I believe that's.
Yeah. Are you saying that those who live in their own apartments wouldn't have a cleaner visit? Some may and some won't. That's the bottom line, isn't it?
I mean that they may.
Yeah, right. And so far as a maintenance worker, again, if you live in your own apartment, sometimes you'll need somebody to come and fix things, won't you? And some will need it more than others.
And I would say there's a higher chance that you would do your own cleaning and maybe do your own maintenance.
A higher chance that you would do.
I think that seems more likely to me.
Own maintenance. So if I'm not going to labour the point, but if something went wrong with your washing machine or your oven,
yeah,
you're going to call an electrician or a plumber or somebody appropriate to deal with it, aren't you?
I fixed my own washing machine the other day, but that's neither here nor there, I suppose.
Yeah.
So,
Parties. If you wanted the inspector to know about complaints or issues that have happened with neighbours in terms of noise and disturbance, you, in presenting your case responsibly, would have told us about it, wouldn't you?
I'm sorry, Mr. Grant, can you one more time, please?
In presenting your case responsibly,
yes.
If you had evidence of noise and disturbance being caused to neighbours, you would have told us about that in your evidence, wouldn't you?
Yes, I would have done. I mean, obviously, I'm aware of that third-party representation, but...
Yeah, we'll come on to that in a minute.
Okay.
Okay, so anything other than the third-party representation, if you had any information along those lines, you would have done the responsible thing and put it in your evidence.
I would have included as much evidence as I could find, yes.
Yeah, good. So in terms of the suggestion that was put in cross-examination, where it was suggested that those who are holiday makers or tourists are more likely to hold parties in their apartment than people who live there permanently. Does that question reflect your case or not?
The fact that if tourists might hold parties.
Are you saying that tourists are more likely to hold parties in their apartment than people who live there regularly?
I mean, I would say that people that are staying in serviced apartments would have less regard for their neighbours than permanent residents would.
Yeah, well, we'll pick that up, shall we? Because you've already told us, haven't you, that had you received any complaints or information about noise and disturbance, you would have told us about them, wouldn't you?
Yes.
Yes. And you haven't, have you?
No, I haven't.
No. Right. The 1994 management scenario that was raised in cross-examination of Mr. Sutton, and it was suggested to Mr. Sutton that in the context of amenity issues, that the arrangements in 1994 would have involved a co-management structure between the bar on the ground floor and the hostel on the upper floors. Now, first of all, is that a point you've ever made in your written evidence or any of your reports?
I have not referred to that in my reports.
No. I mean, is that a proposition based on your instructions? Is that part of your case?
Is what part of my case, sorry, that they
That the 1994 management arrangements would have meant that there was a joint management structure between the ground floor and the upper floors. Is that part of your case, you, Mr. Daines?
I mean, I would say there should be. I mean, there should have been something of that sort to mitigate some of the impacts.
Well, was there a condition attached to the permission relating to the joint management between the ground floor and the upper floors?
I mean, I would have to look at the permission again to confirm either way.
Okay, and the answer is there isn't, but have a look if you'd like to.
And I can take you on your word on that, Mr. Cron.
Yeah, and have you seen any Section 106 planning obligations dealing with management structures between the ground floor and the upper floors?
I have not, no.
No. And you've seen, haven't you, from the wealth of material in the files within your Appendix AP13, that over a significant number of years, the ground floor was being operated by an entertainment company because they were the ones applying for variation of hours and so on, weren't they?
I'm aware that some of those variations exist within that file. I'm not, as I've said previously, I haven't included that file in my addendum proof. That was just provided more for your benefit than it was.
Well, it's in your appendices at AP13, isn't it?
I know, yes, it is.
Yeah. And there is no evidence at all, is there, that pursuant to the 1994 planning permission, there would have been a joint management structure between the bar and the hostel, is there?
Not that I'm aware of.
No. Next point, please, that was raised in cross-examination of Mr. Sutton, the management plan. So the management plan, can you turn please to Mr. Sutton's Appendix 12?
Yes, okay.
Now, Mr. Daines, you understand, I hope that the management plan is something which it is proposed can be conditioned in the event that the inspector granted planning permission pursuant to ground A. Yes?
Yes, I'm aware of that.
And in terms of the approach to that condition, and there are two ways of dealing with it, aren't there? One is to condition a specific plan, or the alternative is condition a plan to be agreed. Yes?
Yes.
And can you just have a look, please, at paragraph 1.1 of the plan?
Mm-hmm.
And this is the response to complaints. It was a point that was put in cross-examination. Do you see that the first part of 1.1 refers to the response to complaints relating to guest behaviour before 1 a.m.?
Mm-hmm.
Yeah?
Mm-hmm. And
the second relates to other complaints within a reasonable time frame, but within 24 hours. You see that?
Mm-hmm.
And it was put to Mr. Sutton, wasn't it? And again, I'll paraphrase it. The second part of that isn't very good, was the gist of it.
Mm-hmm.
Yeah, and that presumably reflects a position that your view as well, does it?
That's correct, yes.
And so far as the second part of that, if the second part of 1.1, the other complaints, was removed, so that 1.1 and 1.1, the 1 a.m. time was removed, do you see? So
Yes.
that it read that complaints pertaining to guest behaviour will be responded to within a 2-hour time frame. See that?
Yes, I do see that.
That then would be an acceptable response time to any complaints that were received, wouldn't it?
I'm not sure I could say that was an acceptable response time. I think as a comparison, if somebody did have a noise complaint, they could go and knock on the door of their neighbour and raise their issue directly with them immediately, as opposed to waiting within a 2-hour time frame. So I think that it would be different there. But in terms of more broadly, if a 2-hour time frame is acceptable or not, I would need to consider that.
Well, somebody doesn't have to make a complaint, do they? If somebody chooses to make a complaint, then a response time of 2 hours to address it is reasonable, isn't it? Because so far as the first part of that paragraph, it wasn't suggested in the context of before 1 a.m. that there was any issue with a 2-hour response time frame, was there?
I'm sorry, say that again, Mr. Grant?
Yeah, the first part of 1.1,
Yes,
the 2-hour time frame.
yes.
But when this matter was being explored with
Yeah.
Mr. Sutton in cross-examination, it wasn't suggested, was it, that there was any issue or unreasonableness about a 2-hour response time frame, was there?
I don't. If whether there was or wasn't, I would still say that a 2-hour time frame may not be reasonable.
What do you say is an acceptable time frame to respond to a complaint?
Can I interrupt it really? I mean, what I think the question really being put to you is, can a reasonable management plan be agreed between the parties if it was a matter for condition?
Yeah.
Yes, I mean, I think one can be, but yes, in terms of the specifics, that's obviously not something I could say right now.
Right. Okay. Thank you. Thank you. So you put it more articulately than I've been trying to put it. We're nearly done on amenity, but a couple more points, please. First of all, CCTV. And if you don't know the answer, then just say so. But are you aware of CCTV around the entrance and hallway and stairs?
I would need to go back and check through my site notes to see if I took pictures of that. That's normally something I would record, but off the top of my head, I don't recall. Okay,
again, so I think that might already be on your site visit list of points. Next, please, refuse.
Mm-hmm.
At the time of your proof of evidence, had you seen yet the third-party representation in terms of rubbish being left?
I had seen it, yes.
Yeah. And again, you told us to remember at the outset of your cross-examination before lunch that in your proof of evidence you put down everything that occurred to you as being relevant to your case.
You did ask me that broad question, and I did answer that. I will say, in relation to the third-party representation, Hackney Council obviously suffered a cyber attack and underwent a new sort of file management system, and so it wasn't. I wasn't able to locate it at that stage, although I had previously seen it.
So you'd seen it. So you knew at the time you were writing your proof of evidence that there had been a representation made about rubbish. Yes?
Yes, I was aware.
And when you were writing your proof of evidence and you were taking the opportunity to set out the council's case on amenity, you didn't set out, did you, that refuse was a part of the council's concern in respect of this issue?
No, I didn't.
No. When did that first become part of your case?
I think it became part of my case when I was again able to locate the third-party representation.
When was that?
I do not know the date off the top of my head, but it was after the submission of the proof.
And in terms of the same question you were asked, or that was suggested by the inspector to tidy up the questions that I was asking really about the management plan.
Yes.
Again, you've seen in the draft management plan there's a reference to refuse, but you would expect, wouldn't you, that so far as a problem about where rubbish is left, that is something that is capable of being addressed by way of a condition in respect of a management plan.
Again, that would be subject to detail, but potentially yes.
And so far as any condition that where a management plan was conditioned, you made a point in evidence in chief about control. But of course, were there to be a breach of a condition, you'd be in a position, wouldn't you, as a local authority, to issue a breach of condition notice?
Depending on the condition, yes.
Yeah. Lastly, on amenity, during your evidence in chief this morning, you referred to fumes and odour. Do you remember that?
Yes.
Now, it may be there's a simple answer, otherwise we'll have some more questions about it. But is the simple point, was that a point that you were making in respect of rubbish? Is it part and parcel of the same point, or is it a different point?
It is, yes.
Same point.
It is the same point. Yes.
Okay, good. Well, I don't need to ask you any more about that then. Fine. So we can move away now from amenity and into the policies, first of all, for visitor accommodation. And can we start, please, with policy LP25? And so it's set out at 8.30 of Mr. Sutton's proof. I've been using that, but I think it is in the appendices as well.
It's appendix 11 of mine.
Thank you very much, Mr. Daines. Do you have that in front of you?
I do, yes.
Great. So 8.30, I'm so sorry, policy 25. Policy 25 provides a list of criteria, and there is between each one the word and it's clear, isn't it, that all of the criteria to be met in order for the policy to be met. Yes?
Yes, it is.
Now, I'm not going to go through 1 to 6 with you, because on the whole, those will be dealt with elsewhere within your evidence. But it's little 7. You've heard Mr. Sutton explain, haven't you, that there is the development doesn't comply with little 7. That's the wheelchair access, and that therefore it doesn't comply with policy 25. Correct?
I'm sorry, say that again.
Yeah, by failing little 7,
yeah,
the development does not comply with policy 25.
Do you mean only 0.7, or do you refer to the policy in its entirety?
I'll put it again.
Okay.
You heard the questions a moment ago.
Yes.
That each limb, each criterion is expressed with an and in between.
Yes.
And that a development has to meet all of the criteria in order for the policy to be met. Yes?
Yes, that's right.
And
yes.
Mr. Sutton, in his evidence, acknowledged, didn't he, in evidence in chief, I think, that because the development doesn't include at least 10% wheelchair accessible bedrooms, the development doesn't meet little 7 and therefore does not meet the policy as a whole.
That's correct, in addition to other points of that policy, but yes.
Just coming to that, just answer the question.
Sorry.
It doesn't meet the policy as a whole, does it?
Yes.
Right. And in terms of the extent of the departure from the policy, as it's been put by my learned friend, in terms of the extent of the departure, the inspector is then able, isn't he, to consider the development against the other criteria set out at 1 to 6. Yes?
Yes.
and you in particular, I think, through your evidence and through cross-examination, have identified 3, 4, and 5, which reflect the 3 objections in the enforcement notices.
Mhm.
Yeah.
Yes.
And so far as 3, 4, and 5, that's the loss of housing or opportunity. Is that the opportunity? The loss of housing or opportunity, that wasn't in the reasons, but we'll come to that. Compatibility with surrounding land uses, impact on the character and function of the area, and amenity. So far as those issues are concerned, we're dealing with those individually. So we've already dealt with little 4 and little 5, and we're about to come in a few minutes onto little 3. Okay?
Okay.
So that the inspector can consider the extent of departure. So alongside policy LP 25, when considering the policies for visitor accommodation, the inspector also needs to look, doesn't he, at policy E10 in the London plan.
Yes.
And E10, we were looking at it earlier. Do you remember I promised you we'd come back to it because you were going into other points on E10?
You did promise me that, yes.
And if we turn back to it at page 273, yeah?
Yes.
And you wanted to draw attention to the final sentence of F. You see about local amenity or the balance of local land uses.
I did refer to that in relation to your previous point, yes.
Yeah, and so far as that point is concerned, that's that debate is encapsulated, isn't it, by the way in which the parties put the amenity point and the surrounding land uses point that we've already been through. Yes.
Yes.
Yeah. So in terms of H of E10, again, this is about wheelchair access.
Yes.
H1 and 2, which are expressed as alternatives. Do you see?
Yes, I do see them, yes.
And again, you're aware from Mr. Sutton, the appellant acknowledges that the appellant doesn't meet H of policy E10. Yes?
Yes.
But unlike policy LP 25, paragraphs A and H, A to H of E10 are not expressed, are they, with the word "and" in between each paragraph?
They are not expressed with the word "and" in between each.
No. And unlike policy LP 25, nowhere is it said that that a development has to meet all of paragraphs A to H in order to satisfy the policy, does it?
It does not say that, unlike the adopted plan in Hackney's adopted development plan.
Pardon?
Sorry, I said yes, effectively.
Yes, okay, thank you. And that's why the way in which it was put to Mr. Sutton in cross-examination was that the development was not fully consistent with E10. Do you remember the way that question was put on Friday?
Okay.
Yes.
Mm-hmm.
So in terms of E10, a development can be at odds with a particular paragraph within the policy, but is still capable of complying with the policy overall, isn't it?
In relation to policy E10, it doesn't comply with H, but yes, it might comply with some of the other points within that policy.
Yeah, and if the inspector took the view that the development complies with all of A to G, then the inspector is entitled, isn't he, to reach the conclusion that the development is consistent with policy E10 overall.
I mean, I would leave that for the inspector to decide. I would say that the development plan needs to be read as a whole, and that includes LP25, which obviously does have sections in it which is not compliant or not compliant.
Yeah, but I know that, but I'm asking you about E10 and compliance with policy E10.
Okay.
If the inspector took the view that a development or the development complied with paragraphs A to G, the inspector is entitled, isn't he, to conclude that the development is compliant with policy E10 overall.
I believe the inspector is entitled to conclude that if he so wishes.
Yeah. And so far as E10 is concerned, I don't want to labour the point we made in respect of SD4, but in the statement of common ground, you took the view that you weren't prepared to agree that policy E10 was relevant in this appeal. Do you now accept that it is a relevant policy for the inspector to consider?
I mean, again, I accept that the London plan is relevant for the inspector to consider.
Yeah. Do you expect that E10 is a relevant policy? We're not going through every policy, are we, in this appeal, in the entire London plan? Do you expect that policy E10 is a relevant policy for the inspector to consider?
Yes.
Yeah. Can we have a look, please, at LP12, which, sir, I think Learned Friend said that had been sent through to you. I don't know whether that's reached you yet. I'm looking at it electronically.
No, I'm going to have to just rely on you making me understand the general context of it. I'm writing notes of all your references. I'm very sorry about this. So I don't think because we've changed to having the council organise the meeting. We used to have an officer with us who organised it on our behalf, and they would be with us through the inquiry. And so anything that came through would be immediately sent to us. But because everyone's at home working, or a lot of people are, the system's not quite as efficient as that anymore. So I do apologise for that.
Not at all. I think we've all got so used, sir, to working in the previous virtual inquiry arena where we had the luxury of having an officer at PINS to help us on these things.
I know. Well, I know when I was asked how I felt about virtual inquiries, I said I preferred the live ones. But if we always had the officer at hand, then I wouldn't mind. And then they took him away. So there we go.
Okay. So are you happy for me to carry on with LP12?
Yes,
and
I am, yes.
To follow it? Mr. Daines, LP12 was another policy, wasn't it? Where in the statement of common ground, you refused to agree that LP12 should be included as a relevant policy for the inspector.
I mean, again, I wouldn't say I wouldn't use the word refused, but yes, we didn't include it in the statement of common ground. Yeah,
and it ended up saying that it's the appellant who considers LP12 to be relevant, didn't it?
I would need to look at it, but yes, if that's what it says.
Yeah. And LP12, in spite of you saying you didn't consider it to be relevant, that was relied on for a considerable part of Learned Friend's cross-examination on Friday. Okay. When did LP12 become a substantive part of your case?
I mean, again, the Hackney's development plan has always been a part of our case. I mean, and I appreciate obviously that I hadn't referred to that policy specifically. In terms of when it had become part of our case, I must admit I could not tell you the specific date.
Yeah, was it Friday?
I don't know what day was Friday. No, sorry,
yeah, was it Friday when that became part of your case?
No, I do not believe so.
Well, in the multitude of opportunities you've had to set out your case, going all the way back to your delegated report, have you ever indicated reliance on LP12 up until the time it was put in cross-examination on Friday?
I mean, I will say that LP12 was adopted after my delegated report.
Yeah, and in your statement of case or proof of evidence, did you indicate any reliance on it?
I have not referred to it specifically.
No, and if we have a look, in fact, just briefly in your proof of evidence. at paragraph or section 4.
Mhm.
You set out there, don't you, what the policies that you consider to be relevant policies under the heading relevant policies. Yep. And at
Yes.
4.3 from the local plan, you refer to LP2, LP24 and LP25. Yep.
Mhm.
And again, entirely silent, aren't you, in respect of policy LP12?
I mean, yeah, as I
Yeah.
previously said to you, I don't specifically mention it.
Well, you don't specifically mention it, but you identified what you regarded as relevant, and then in the statement of common ground, you identified that LP12 is not relevant, didn't you?
I mean, again, I didn't write the statement of common ground, but I was aware of that document.
Mr. Daines, you told us at the outset, remember we went through it all this morning,
Yes.
that Christine Stevenson, the borough solicitor, was liaising with you
Yes.
in respect of the statement of common ground.
Yes.
Right.
Yeah.
Now let's look at LP12.
I accept that.
Can I just interrupt, Mr. Grant? I'm sorry, Mr. Stretton, you have your hand up.
Yes, sir. It's only because Mr. Grant said that the first time it was raised was in cross-examination on Friday. It does feature in the council's opening, so at least from that date, it formed part of the council's case.
Okay, thank you very much for that. Thank you. Mr. Grant, please carry on.
Thank you. LP12, if we just look at it briefly, please.
Yes, okay.
You'll have to bear with me because I've got it. Disappeared off my screen and I have it back. Let's go straight, please, to paragraph D.
Yes, okay.
And so far as paragraph D is concerned, the point that's being made, and we can paraphrase, can't we, is that priority is given to self-contained residential units over and above other forms of residential accommodation, including visitor accommodation. Correct?
Yes. Yes.
And 2 points, really. First of all, that is subject to a caveat in respect of feasibility. Do you see that at the very end of that paragraph?
Yes.
So
Feasible to deliver see-through residential development on the site. Yes.
Yeah, and we're going to come back to that. But the second point I just want to explore with you is this, that so far as LP12 is concerned, LP12 sets out, doesn't it, that priority approach. Yes?
Yeah, it talks about in section D. It does. It talks about the priority of residential land use.
Yeah, but in the London plan, when we look at policies SD4 and E10, which set out the provision of visitor accommodation in the CAS, do you remember we've been through those policies?
Mm-hmm.
Yes? Those policies prioritize, amongst other strategic functions, the provision of serviced accommodation within the CAS, doesn't it?
It does refer to that, but I'm sure it caveats that too.
Well, we've been through policy E10, haven't we? And we've been through SD4. Yes?
Yes.
And in so far as policy E10 is concerned, if the inspector doesn't take you up on your point about amenity and the character of the area, then the only conflict with E10 would be in relation to the wheelchair access point, wouldn't it?
Yes.
Yes.
Yeah.
In other words, so far as policy LP12 is concerned, that doesn't make any allowance, does it, for the London strategic policy relating to the CAS?
I'm sorry, Mr. Grant, I was just reading the policy. Can you ask me that question again, please?
Yeah, so far as LP12 is concerned, that doesn't make any allowance, does it, for the strategic policies in the London plan relating to the CAS?
It does not refer to the CAS. No, it does not.
No. And therefore, as often happens in a policy environment, whereas LP10 pulls in one direction away from the development, subject to the feasibility point, policies E10 and SD4 pull in a different direction in terms of the CAS, don't they?
In terms of, I mean, again, Hackney's policies don't. This policy of Hackney's LP12 doesn't refer to the CAS. No, it doesn't.
Right. In terms of the, I said we'd come back to feasibility, and we will in a few minutes. In terms of the loss of housing, LP24 is the policy in the local plan that you, I think, are particularly draw reliance from. And can we just have a look, please, together at LP24?
Yes.
We will find it, won't we, within your appendices.
Yes, it's number 10.
Thank you. And so far as LP24 is concerned, LP24 seeks to prevent the loss of housing, but then sets out, doesn't it, a series of proviso conditions, if we can call them that. Yes?
Yes.
And what it tells us is that a change of use or land or buildings involving loss of residential floor space will be resisted and will only be permitted where at least one of the following conditions are met.
Mm-hmm.
Yeah. And you heard from Mr. Sutton's evidence that the condition that he suggests is met is condition 1, which is that the land or buildings are no longer suitable for residential use, and it's considered inappropriate to provide residential accommodation. Yes?
Yes.
Now, if the inspector accepted your argument that the C3 residential use was the lawful fallback,
Yes.
then I think we've agreed already that the lawful fallback is the lawful fallback in respect of each unit.
Yes.
And therefore, the lawful fallback in respect of each unit would be C3 residential use.
Yes.
In other words, a flat, self-contained flat.
Yes, a residential unit, yes.
Yeah. And in terms of the suitability of each unit for a self-contained residential flat,
Mm-hmm.
the inspector is entitled, isn't he, to have a look at the living conditions that would be provided.
Yes, yes, he would. That would be provided or would have already been provided?
No, the living conditions that would be provided if the landowner reverted to the lawful C3 residential use of each unit. Okay? And in terms of those living conditions, one of the living conditions that the inspector is entitled to have regard to is the size of the units that would be provided. Yes?
Yes.
And if we have a look in the Statement of Common Ground, at paragraph 10,
Yes.
we can see there can't be an agreed table setting out the floor space for each unit.
Yes.
Yes. And these are all one-bedroom units, and therefore, as you'll know, I think the applicable standards refer to a minimum of 37 square meters, don't they?
Yes, they do.
And we can underline, can't we, the word minimum, because that's how they're expressed rather than a target.
Mm-hmm.
And in respect of all of the units set out, the 24 set out on this table, the largest is 20.4 square meters, isn't it?
Yes, on this table, that's correct.
So the largest of the 24 units is only a little bit more than half of the minimum standards which are set out in the space standards. Correct?
Yes, that's right. Yes.
And at least half, I think, of these 24, I think it may in fact be exactly half, but around half of the 24 units are below 14.5 square meters.
I mean, if you say so, yeah, as in.
Well, you can see it in front of you, can't you?
Sure. If you want me to comment on if it's how many of them.
Okay, I understand. And in respect of other living conditions that the inspector is entitled to consider, that includes, doesn't it, the provision of internal and external private and communal external amenity space.
Sorry, what was the question on that point?
In terms of other living conditions considerations,
yeah,
the inspector is entitled to consider. That also includes the provision of private and communal external amenity space.
Yes, it does. Yeah.
And again, if you're right and the lawful use is C3 residential and the landowner was therefore able to revert to that in respect of any of these units or all of them, none would provide any private external amenity space, would they?
In their current form, no, they wouldn't. But I suppose on that point, I mean, nothing is to prevent an application to remedy that.
We'll come to that in a second. None, that was about private amenity space. None would benefit from any communal external amenity space, would they?
Again, in their current form, no. But again, there's nothing to.
No, we'll come to that point. Don't worry. All of them are single aspect, aren't they?
I believe so.
None of them have wheelchair access in common with the service departments.
They do not know.
Yeah. And in terms of your point that you made in chief and that you twice were keen to set out just then, if the landowner has a C3 lawful use of any of these units, the landowner is entitled to revert to that lawful use, isn't he?
Yes.
And therefore, if that unit was 14 square meters, for example, the landowner is entitled, isn't he, to use that as a C3 residential dwelling of 14 square meters.
Yes, they are.
Yes. And whether or not a landowner wants to submit some sort of application in the future to change configuration is speculative and beyond anybody's control, isn't it?
In this situation, yeah, I mean, there is nothing to guarantee that they would. Obviously, I would strongly encourage them to do so. But
you might do, but if they told you thanks but no thanks, that's up to them, isn't it?
Yes, I don't have any problem.
So in terms of the lawful fallback position, if you're right on C3 residential use, if we take, for example, Unit 2A, which is 13.67 square meters, the landowner is entitled to say, I'm going to use this as a self-contained flat of 13.67 square meters, single aspect, and with no private or communal external amenity space, aren't they?
They are, yes.
Yeah. And if the inspector were to conclude to reject the council's submission on the lawful use was C3 residential, and to reject the appellant's position that the lawful use is hostile, but were to conclude there is nil use. Okay, you with me so far, Mr. Daines? I know it's a long question, but and were to conclude nil use.
Yes.
Then, so far as the 1 unit versus 24 units point, I'll deal with that in submissions. But what I want to ask you about is this. In the absence of a complete rebuild of 104 to 108 Curtain Road, in the absence of a complete rebuild, no matter how the units are reconfigured, the site is not capable, is it, of providing external amenity space?
No, I do not agree with that. I think on that point, I mean, you were saying what, short of a complete rebuild?
No, short of a rebuild.
Ever rebuild, but you did say, but to include some form of alterations. Did you say?
No, I didn't. No, I didn't say that. Where?
Do you mind asking me the question again, please?
Yes. In the absence of a rebuild,
Yeah.
where is the capability to provide external amenity space?
I mean, you could provide that on the upper floor, on the roof of the building.
Where do the flats on the 4th floor have their amenity space?
I do not know where the flats on the 4th floor have their amenity space.
So that is a point I'll address in submissions because it's in the papers. In terms of going back to the loss of housing.
Yes.
2 days before the start of the inquiry, in the Statement of Common Ground discussions, Christine Stevenson, the borough solicitor, acting in liaison with you, as you've already explained, wrote to the appellant in correspondence that we have in the inquiry papers to say that the loss of opportunity for housing was a matter that the council relied upon. Do you remember?
Yes, I do recall that.
Yes. And do you recall that the appellant responded through the appellant solicitor and said, well, that's never been part of the council's case? Remember that?
Yes, I do recall that.
And can you take up then, please, the appellant's addendum appendices at Appendix 1?
Are these the exterior and street scene? Is this what you're referring to, Mr. Grant?
No, the appellant's addendum appendices, Appendix 1. It's a series of emails in relation to the Statement of Common Ground.
Yes.
And if you turn, please, Mr. Daines, to the second page, you'll see an email from Christine Stevenson to Christine Hereward, dated the 22nd of September at 5:17 in the afternoon.
Yes.
Copying in you and Mr. O'Connor, your team leader. And in that email, Ms. Stevenson writes, having discussed this further with officers, see that?
Yeah.
That includes you, doesn't it?
That does include me, yes.
I am advised, and then the reference to the inclusion of opportunity to provide housing.
Yes.
See that? And then Ms. Stevenson goes on in the following paragraph, the application of which forms a central issue in dispute between the parties. Do you see that?
Yes.
It has always been part of the council's case.
Yes.
Now, we earlier on explored the different stages of the evolution of the council's case, from delegated report through to the notices themselves, through to statements of case, through to proofs of evidence. Yes?
Yes.
Nowhere in any of those documents did you set out that you, the council, relied on the loss of opportunity for housing as part of your case? Did you?
No, I have done.
Show me where.
Okay. I mean, I refer to policy LP25, and I refer specifically to that point.
Let's have a look at it. You're referring to paragraph 7.34 in your proof, aren't you?
I could quite well be. I mean, this is referring to the policy that you brought me to a moment ago, and it seems somewhat surprised to see the word opportunity there. It's that policy, I think.
7.34 in your proof of evidence. Is that what you were trying to take us to?
I'm sorry, Mr. Grant, one moment, please. Yes. Yes.
Is that the paragraph you wanted to refer us to?
That is one of the paragraphs.
Right, well, let's look at it properly, shall we?
Okay.
Because do you see in the second sentence, you say the development must, and then you set out at little 3, little 5, little 6, and little 7. You see that?
So 3, yes.
Yeah.
Okay.
And because you set out little 3 in full, which means the loss of general purpose housing or opportunities to provide conventional C3. Do you see that?
Yes, I see that.
And then towards the end of the paragraph,
yes,
you identify that you take the view that there is conflict with criteria 3, 5, 6, and 7.
Okay.
And in the first part of that sentence, where you identify the conflict with that criteria,
yes.
What do you say results in that conflict?
Would you like me to read the sentence? Is that what you're asking me to do?
There's only 5 words. What does it say at the beginning of that sentence?
It says the loss of the 24 residential units at 104 to 108 Curtin Road is contrary to this policy as criteria C, 3, 4, and so on and all that.
Yes. So in identifying the conflicts with 3, 5, 6, and 7, you are relying, aren't you, on the loss of the 24 residential units, aren't you?
I mean,
black and white.
Earlier in that paragraph, I very clearly write or opportunity to provide conventional C3 housing.
No.
Are you saying I've written it right here? I don't understand.
No, Mr. Daines. Mr. Daines, at little 3, you set out the entire criterion of little 3, don't you? You write it out as you do with little 5 and little 6 and little 7, don't you?
I do write it out.
Yes. And when you then say why there is conflict with those criteria, you identify the cause of the conflict as the loss of the 24 residential units, don't you?
I mean, I've written that, but again, I've also said that I've given the site address and saying it's contrary to that policy. I spelled out earlier what that policy states. I think that's quite clear.
No, it's not, because you are identifying why you say that policy is conflicted, aren't you?
I mean, I've included that policy in saying that it's contrary to it.
Mr. Daines, if you set out, for example, the whole of policy E10, yes?
Okay.
And you concluded that there is, in your view, a conflict with policy E10, you would identify, wouldn't you, what it is and which aspect of E10 is conflicted, correct?
I mean, you're asking me an unusual hypothetical question there.
It's a matter of approach. If you look at the bottom of 7.34,
okay,
you clearly say in the final sentence, the loss of the 24 residential units is contrary to this policy as criteria 3, 5, 6, and 7 are not met. Do you see that?
I do see that, yeah.
Yes. What you are not saying is that the loss of the 24 residential units and or the opportunity to provide housing is the reason for the conflict. You are relying, aren't you, on the loss of 24 units?
I mean, I would take the point that I could have been clearer in that one sentence of that much larger paragraph.
Well, Mr. Daines.
But I think that very clear, if you would please for a moment, the fact that I've included that point in the paragraph in relation to that policy, which is part of the adopted development plan, I think to suggest that it hasn't been referenced or it hasn't been included or I don't reference it or that it's not relevant, or that I didn't mean for it to be included, I think it seems ridiculous.
Right. Well, I know you may think it's ridiculous, but
Can I interrupt, please? I've taken the point again, Mr. Grant. I can see there's two sides to this, and I don't think you're going to get a change to that just by continuing the cross-examination. So I understand both sides of that argument.
so can I put one point, a final point on the topic? I promise it's the final point. But Mr. Daines, have a look, please, at paragraph 7.32.
Yes, okay.
Right, 5 lines from the bottom. All right, in the context of a different policy, the loss of 24 residential units. Do you see that?
I do see that, yes.
7.34, the sentence we were just looking at.
Yeah.
The loss of 24 residential units.
Yes.
7.35,
Yes.
in the context of housing policy, the loss of 24 residential units.
Mhm.
The next 7.35, because the numbering is duplicated.
Mhm.
Final sentence, the loss of 24 residential units.
Yes, I can read that.
Yeah, nowhere, Mr. Daines, and I suggest you know it, nowhere did you ever, prior to the statement of common ground, sought to argue that the reason for conflict with policy LP 25 is the loss of opportunity for housing.
What I would say, no, firstly, what I would say on that point is that perhaps it's true that I was maybe a little bit too liberal with my copy and pasting of that term when writing these various paragraphs. But again, I have included that in the paragraph very clearly, and I think that speaks for itself.
Okay, well, sir, I'll take your hint now, a couple of minutes later than I should have done, and move on.
Right? No, that's fine.
Before we leave the topic, we'll leave that point, but before we leave the topic of the opportunity for housing, when the inspector is considering the loss of opportunity for housing, that is in relation, isn't it, to conventional C3 housing, is what the policy says.
In relation to the loss of housing.
Would we have to go back to the policy again?
No, I'm sorry.
Let's take it up.
I mean, we don't have to do that unless you particularly want to. If you could repeat the question, that would be sufficient, I think.
Yeah. So far as the loss of opportunity for housing is concerned within the policy, that is the loss of opportunity for conventional C3 housing, isn't it?
Yes.
Right. And when the inspector is considering whether or not there is such a loss of opportunity, the inspector is entitled to consider whether there is a realistic opportunity here for conventional C3 housing, correct?
Yes.
And even if the inspector were to treat floors 1 to 3 as a whole, even if the inspector took against the appellant on that point and decided that was the approach he was taking, the inspector is entitled to consider, isn't he, the extent to which the site is capable of providing policy compliant conventional C3 housing, correct?
I mean, I think if the site, the last unlawful use is C3, then that's not the point. But yes, I'm sure the inspector would want to consider the standard of that C3 housing.
Yeah, and that includes, for example, doesn't it, external amenity space?
Yes.
Okay. Last few minutes, I think. In terms of need, I'm not going to take time on that because you've not called any evidence on the topic of need. But irrespective of whether or not the inspector is considering the need for visitor accommodation as part of the development plan compliance or as a material consideration, it remains, doesn't it, an important matter for the inspector to have regard to.
An up-to-date assessment of need, I suppose, is something that an inspector or somebody would want to consider in terms of that.
Well, I'm not going to get into it. So there's not called evidence. We could go on for another 3 hours if we start going down that route.
Well, I mean, just if you want me to clarify that, that's what it says in the policy.
Right. Well,
So
yeah, we'll deal with that.
I'm not referring to anything else, but that is the terms that's in the policy.
Good. Second, so far as fallback is concerned, we're not going to go over all that again. But do you now accept, because you hadn't identified it anywhere in delegated report, statement of case, or proof, do you now accept that the fallback position is a material consideration to which the inspector should have regard?
Mr. Grant, ask me that question again.
Do you now accept, because you didn't include it in any of your analysis from report through to proof, do you now accept that the fallback position, whatever that is, that the fallback position is an important material consideration to which the inspector should have regard?
Yes.
Good. Just a couple more final points on material considerations, please. Can you take up the statement of common ground, I think one last time, for my purposes anyway, and go again to paragraph 7, which is the policies paragraph.
Yes, okay.
And can you see there, again, there was discussion, wasn't there, backwards and forwards between the parties as to which policies from the NPPF should be treated as relevant policies for the purposes of the appeal?
Okay.
Yes?
Yes.
And the council took the view that, as set out here, only section 5 of the framework is relevant.
That's what it states here.
Yep. Well, that's the council's position as set out in the statement of common ground. So don't just say that's what it says here. But that's the position, isn't it?
Because that's what it says, yes.
Yep. And the appellant considered there to be a variety of other national policies set out in the in that section, which it considers also to be relevant to the determination of the appeal. Yes?
Yes.
And I'm not going to take you through to all of them, but can I take you, please, to the NPPF at chapter 6?
Okay. You'll have to bear with me one moment, please, Mr. Grant. Okay, yes, I'm looking at it now.
And you'll see that within the statements of common ground, there are references, weren't there, to paragraphs 81 and 83, amongst other things. And so far as 81 is concerned, that tells us that planning policies and decisions should help create the conditions in which businesses can invest, expand, and adapt. Significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and wider opportunities for development. See that?
Yes.
And that paragraph of the framework is, again, it's a material consideration to which the inspector should have regard and attach the weight that the inspector thinks appropriate in this case.
Okay, yes.
Agree?
Yes.
And then paragraph 83 planning policies and decisions should recognise and address the specific locational requirements of different sectors. See that?
Mhm.
And you understand, don't you, that the appellant's reliance on the visitor accommodation sector, yes, and the
Yes.
locational requirements, in particular, the presence within the CAS, yes?
Yes.
And again, paragraph 83 is a relevant paragraph for the inspector to consider and attach such weight as he thinks appropriate in due course.
As much weight as he deems appropriate, yes.
Yep. And finally, paragraph 8, that we'll all be very familiar with, achieving sustainable development.
Mhm.
And of course, there are economic, social, and environmental objectives, aren't there?
Mhm.
And so far as the economic objective, which follows through into the paragraphs we just explored, that is to help build a strong, responsive, and competitive economy by ensuring that sufficient land of the right type is available in the right places and the right time, etc. Yes? Again,
Yes.
obviously a relevant policy for the inspector.
Mhm.
And when the inspector is considering the NPPF, it's also right, isn't it, for the inspector to consider section 5, which deals with housing. Yes.
Yes.
And in deciding what weight should be given to that, that is going to pivot to a large extent, isn't it, on the view the inspector takes as to whether or not C3 residential is the lawful use. Yes.
Yes.
Or the view that the inspector takes as to the extent to which there is here an opportunity for C3 residential housing, bearing in mind the constraints of the site that I've already pointed out.
Yes, including the opportunities, yes.
Yeah. And lastly, on material considerations, so far as the quality of accommodation is concerned, do you agree with me as a matter of principle that the inspector is entitled to treat the quality of the service departments as a material consideration which supports the development?
Yes, I do.
And in considering the quality, that includes the quality in terms of the location of the service departments.
The location of the service departments.
Yeah.
Yes. Yes.
And also the quality of what's provided by the apartments. And we've been over that ground. We'll not go over it again. But I think you took the view earlier that it was high quality.
That it was. I think I was referring to it not being basic, but yes.
Okay. And when the inspector is considering what matters, matters is the wrong word to use, what factors to consider when looking at the quality, you're happy to say to the inspector, aren't you, that he can look at the characteristics that you set out in your delegated report based on your site visits in terms of broadband, toiletries, etc., etc.
I mean, yes, you can look at the level of services that I witnessed.
Good. Finally, please, Mr. Daines, ground G, and we only need to be a couple of minutes on this.
Mm-hmm.
Can you take up again the delegated report?
Just one moment, please, Mr. Grant.
It's just to remind you, if it helps, it's Mr. Sutton has it at his appendix 7.
That's okay. I have it in front of me now. Thank you.
Thank you. And can you turn right to the last page, Mr. Daines, under the heading recommendation, paragraph 9.
Yes.
And the recommendation falls into two halves, really. A is for the issue of the notice or notices, and B is in relation to the compliance period.
Yes.
And you'll see that what it says there is that it shall require the breach to be remedied within 3 months of the notice taking effect.
Yes.
And that is dated, as we saw earlier, the 27th of January.
Yes.
And we know that it was the same day when the notices were issued. And so later on the same day when the notices were issued, how long after, just if you can recall it, how long after you and your team leaders signed the delegated report did you sign off the enforcement notices, or was it all done at the same time?
I mean, I must admit, I do not recall. As I'm sure you can appreciate, there was a considerable amount of paperwork in relation to 24 enforcement notices.
Yeah.
So I cannot tell you at what point in that process.
And what was the compliance period that was set out in each of the 24 enforcement notices?
Yes, I can see that the enforcement notice I have in front of me says 1 month.
Yeah.
Yeah.
And what was authorised by the report?
3 months.
Yeah. And is your position, having been reminded of that, is your position that the reports were intended to refer to 3 months rather than 1 month?
I must admit, I do not recall exactly which of those. I mean, thinking back in terms of what the notice required, simply the cessation of the C1 use, then I think that is feasible within 1 month. But I must admit, I do see that the report says 3.
Yes. And what was authorised by the report was 3 months, wasn't it?
That's correct. Yes.
Yeah.
Looking at that now, yes.
Yes. And second point on ground G, in terms of the consequences of extending the compliance period, in your written evidence, and again I'm paraphrasing this, Mr. Daines, to try and make life easy for us, but you referred to the only benefit being private benefit to the landowners. Yes. But where a development is contributing towards the visitor economy in London, there is a public benefit, isn't there, in terms of the contribution to that visitor economy, in so long as it persists?
I mean, there would be some public benefit, but
Yeah.
I wouldn't give that much weight.
And if the inspector were to reject both the appellant and the council's position on the lawful use and to take the view that the use is nil, then the outcome, the likely outcome, is a period of time, probably of some significance, of the units being in aspic effectively, isn't there? Because there's no lawful use to which they can be put until the matter's resolved. Yes?
Yes.
And if the inspector were to conclude that the nil was use, that shows, so it's the end of a long cross-examination. If he was to conclude that the use is nil, then the alternative to the use being held up in aspic for a period of time would be for there to be a continuing contribution to the visitor economy until the end of the compliance period.
I mean, I wouldn't agree with that. But
Which bit don't you agree with?
about your last point.
Yeah, but which bit don't you agree with?
You were saying about the need of a continuing contribution to the visitor economy.
No, I wasn't talking about need. If the inspector finds that there is nil use,
Yes.
yes,
Yes.
then, and let's say the inspector upheld the compliance period of a month, then once the month is up, there will be a period of time, in all likelihood a significant period, where there would be no use to which the units could be put. Correct?
There would be a period of time, but I guess I couldn't comment on how long that or how short that time period would be.
The alternative, if the inspector were to find that there is no harm to amenity or to the character and function of the area, yes, then by extending the compliance period, in the event that the use was nil, the inspector would be enabling the building to contribute to London's visitor economy.
I mean, it would, but it would obviously be delaying the opportunity to provide C3 housing.
Right, okay, I won't labour that point anymore. One final point, and this is just for clarity. So you'll recall that in respect of LP12, I said that I'd come back to the question of feasibility.
Okay.
And so I think I've covered it in other parts of the cross-examination, but just to put it clearly so that the learned friend doesn't think I haven't dealt with it. But in terms of feasibility, if the inspector were to find that the lawful use is C3, yes, if he were to find the lawful use is C3, then the inspector is entitled to consider the living conditions that would be provided when deciding whether or not the provision of residential accommodation is feasible.
Yes.
Yep. And if the inspector were to find nil use,
yes,
the inspector again is entitled to consider, and we won't tread over the same ground again, is entitled to consider whether or not the delivery of C3 residential development is feasible having regard to the site constraints.
Yes.
Yeah. Good. So I'm sorry I've gone on so long, but that's the end of my cross-examination. Thank you very much, Mr. Daines.
Thank you very much. Mr. Streeton, I'm not sure how long you'll be in your re-examination, but I think perhaps I'll take a break now and then we'll come back to your examination.
Yes, sir, that's fine. I have 6 topics, most of them short. One of them might take a little bit longer.
Okay, then that's good. Did you get a list of conditions?
So there are...
I did ask about that at lunch. It was I discussed it with the other officer for Hackney, and I don't understand that we've seen one yet, but that doesn't mean there isn't one.
No, well,
so I think
they were circulated at about just before the restart.
How many conditions
have been circulated to the council solicitor?
Okay, well, if you could, if they're agreed, that would be helpful. And if we could just have the ones which aren't agreed, then that would be also helpful. There's no point in sending it through because nothing's got through to me. It's very poor.
I think it's 3 or 4 conditions. So.
Okay, so it's not too many.
Yeah.
I do have my doubts that we'll finish today. I don't know whether you've got any thoughts on that still. I mean, because you said you wanted time to adjust your closing submissions anyway before we got to that. I think we'll be at 4 o'clock very, very shortly, 4:30. I don't know. Is there going to be any costs applications?
So there is. That's brief. It's in relation to one issue, implementation. And I sent through to my learned friend the application last night. It was late last night, so he may not have seen it till this morning, but I sent it through last night.
Right.
I saw it this morning. I confess I haven't digested it. I skimmed it, so I know broadly what it says, and I don't think it will take me forever to respond to it.
No.
I probably will need 20 minutes to tidy my closing up after I've re-examined. Probably not more than that, but it is 20 minutes.
Yes, and to give the closings will take some time, given what we've gone through.
I'll be around an hour, I think, in closing.
I know, and I don't really want to go until 6 or 7 or 8 o'clock. Well, what I'm basically going to propose is that, and tell me if you disagree, please. I think we certainly have time to finish the evidence in chief and do that. I think we should have time to do the conditions, particularly if most of them are agreed in the break now. I think probably we'll have time to do the costs application if it's as brief as you sort of suggest it might be, and I can understand that. Then I would suggest that I take the closings in writing after the event, and we'll have to agree a way of exchanging the closings. And I mean, I would rely on you not. I don't like taking closings in writing, to be perfectly honest, because it can lead to difficulties. And I've had this sort of tit for tats going on for some time after the event, when really it should just be like it at the inquiry, where one person reads it out and then the other person reads it out, sort of thing. So I think if I can ask you, not to get into that tit for tat, then we could just simply have the closings in writing. I could ask Mr. Streeton for you to give your closing sort of one day, and for Mr. Grant for you to circulate it, and then Mr. Grant to give his closing the next day, or something of that sort. So if you can have a think about exactly how you'd like me to do that process, but would you be generally in agreement to that?
So I am in principle. If I could just take instructions in the break, but I can see the sense of that. So far as costs is concerned, I've got no objection to dealing with it in that way. Although, of course, ordinarily we'd have the costs following the closings. But I mean, one alternative would be to have the Len Friends got my costs application, so he could respond to it at the same time as he sends his closing, and then I can respond to that as a sort of annex to my closing. But I can deal with it that way, or to proceed with it this afternoon if you prefer.
I'd be happy to do that as well, and that seems quite a sensible approach as well, to be honest. So I'm happy to do that.
So I'd be happy to do that. And of course, Mr. Grant could then reply to it with his closing. And for whatever it's worth, my undertaking to you, and I'm sure Mr. Grant's is the same, is that we would not get into the tit for tat on it. I will close and make my submissions. He can say what he likes about them in his, and that will be the end of the matter.
All right. Well, we'll take the break, and we'll then have the re-examination, and then we'll deal with conditions. And I think at that point, I'll probably just arrange a site visit, and we can close the inquiry for evidence for closings in writing.
I'm grateful. So I after I re-examine, will run downstairs so that I can be with Mr. Daines for conditions, because we haven't discussed them and won't be able to discuss them because he's still in Purda. But I promise that will take about a minute and a half.
All right, but I don't know about you, Mr. Grant, but I certainly don't mind you discussing conditions. Would that be a problem to you, Mr. Grant?
No, not at all.
No. So if you want to discuss conditions in the break, then I certainly trust you not to discuss important matters.
I'm grateful. I will then use the break to do that.
All right, thank you very much. So it's 22 now. Should I break till 4 o'clock for you to give you a little bit of time to do that? Okay, so we'll resume at 4 o'clock. Thank you very much.
Thank you.
Oh, thank you. The inquiry is now resumed. Can you turn the camera over a little bit, Mr. Stratton, because I can't see you at all. Can you hear me, Mr. Stratton?
Yeah, we're trying. Sorry, so we're trying.
Yeah.
Unsuccessfully.
That's fine. That's enough. I can see you now. Then, Mr. Stratton, if you'd like to re-examine, please.
Yes, sir. So, good afternoon, Mr. Daines. Just 6 topics to deal with. The first is need, and you were taken in particular to paragraph 83 of the MPPF. Mr. Sutton agreed that LP12 is up to date. And of course, could you explain what you understand up to date to mean?
In relation to LP12?
Well, just as a matter of principle, what does a policy being up to date mean?
Oh, that it is the current policy and that it has been adopted. The development plan is the current plan, adopted plan.
And in terms of accordance with the MPPF, what does it mean?
What does what mean, sorry, in relation to
The concept of up to date.
Oh, that it is the current planning policy framework, and the adopted planning policy framework.
Yeah, and if you look at MPPF paragraph 35, please, that deals with the test of soundness that a development plan and its policies have to meet to be adopted. Could you look in particular at subparagraph A of the MPPF?
Which pen is that, sorry?
So paragraph 35A.
Okay.
And could you just read out what that says?
So 35A states positively prepared, providing a strategy which, as a minimum, seeks to meet the area's objectively assessed needs and is informed by agreements with other authorities so that an unmet need from neighbouring areas is accommodated where it is practical to do so and is consistent with achieving sustainable development.
So in terms of LP12 being found sound and adopted, would it have had to accord with that requirement and been found to do so by an inspector?
It would have done, yes.
And then could you look at LP12, please? Which is in your, no, it's not in your appendices, it's
Yes.
separately.
Mm-hmm.
But what does that say about the need for residential accommodation and visitor accommodation?
That they will only be permitted where applicants can demonstrate that it is not feasible to deliver C3 residential development on site.
Yeah, and you could read on.
As in
Within LP12.
Yes.
And in particular, if you look at LP12D,
Yes.
what does it make clear about the need for residential accommodation as against other forms of accommodation?
It says, yes, self-contained residential units are the priority residential land use in the borough and type of land use for which there is the greatest need.
So what do you understand that to be saying?
The self-contained residential units has far greater need than any other.
And if you look on in the policy, there's a reference to visitor accommodation, isn't there?
There is, yes.
So what does that tell you about the relative need for residential as against visitor accommodation?
The residential units have a far greater need in comparison to visitor accommodation.
And given that the policy is up to date, do you understand that that's changed since the policy was adopted?
Do I understand what, sorry?
That there's been any change in the need position since the policy was adopted?
No, I do not have any change.
Thank you. If you could then please look at LP24 and you were asked about the concept of suitability for residential use. Do you recall that?
I do, yes. I'm just trying to get to LP20. Yes, I do recall.
And you were asked by Mr. Grant, short of a complete rebuild, would this site be capable of providing external amenity space?
Mm-hmm.
I'd like to ask you firstly, short of a complete rebuild,
would this site be capable of conversion to C3 residential use to a satisfactory standard in your view?
Yes, I believe it could.
And why?
Because you could obviously enlarge the units. You could make them double aspect or dual aspect, and obviously you could provide amenity space for the residents.
But dealing with amenity space, do you know what the current position on the roof looks like? And if you don't know, then say perhaps it's something the inspector can take note of on site.
I think the current I think it's a mansard roof extension.
Yeah. And so in terms of the roof space, what will be available for external amenity space?
I mean, again, that roof space could be altered to include rooftop amenity space.
And if it couldn't, assume that it weren't possible to provide external amenity space, would that in your view, or to what extent would that in your view be a fundamental objection, meaning that the site was incapable of providing residential accommodation?
I mean, I would certainly say it's not fundamental. I mean, you know, that there are other residential units that do not have private external amenity space.
And in your role as a design officer, what overall view would you take of the suitability of this site for residential use?
I mean, I think it could certainly be, it's certainly suitable for residential use.
Thank you very much. Then just dealing with LP4 in a tiny bit more detail, you'll see if you look at criterion A5,
Yes.
a reference to units not of a suitable standard, essentially.
Yes.
What does, also I'll ask you this, does policy LP24 in light of that apply to units which fall below minimum standards?
I mean, it can do.
Why do you say that?
Well, because obviously it makes provision for them to be enlarged to meet residential space standards.
So what approach in terms of protection does criteria A5 suggest policy LP24 takes even to substandard units?
I mean, it doesn't prohibit them.
Thank you. Moving on from that, you were asking, this is a very short point, about the difference in delivery levels between residential accommodation and C1 service departments. And it was said, well, you would get more Amazon deliveries, wouldn't you? In terms of deliveries from companies like Amazon or Deliveroo, what sort of time frame will they deliver in? Do you know?
I suppose they would deliver during the day, I guess.
But as in, do you know how fast you could get groceries delivered through a company like Wheezy, or food delivered from a company like Deliveroo, or?
You can have food delivered within the space of 20 minutes.
So is that something that you could do as a visitor rather than as a permanent resident?
Yes, it's something that you can do.
And do you think there's likely to be very much difference in the extent to which people get some items delivered like that as visitors?
No, I don't believe so.
Thank you. Next point. Yes, you were asked about the position as explained by the appellant in relation to assured short hold tenancies, and you said in your evidence that they wouldn't evidence subletting, and then you actually corrected yourself and said no, they may not evidence subletting.
Mm-hmm.
And I just wondered, could an assured short hold tenancy contain any terms which would shed light on whether or not subletting was taking place?
I mean, they could.
In what sense would that be?
Well, I suppose they could go into the details of what those agreements are like.
Have you ever seen in a short hold tenancy which prevents subletting as a term?
I have, yes.
And is that something that would be relevant when considering the question of whether subletting was taking place?
Yes, it would be.
So would it have been relevant to see those assured short hold tenancies?
Absolutely, yes.
And in terms of what you have seen on evidence of subletting, what evidence of subletting have you seen put before this inquiry?
I mean, I have seen no evidence of subletting put beyond inquiry beyond I think Mr. Hakimi suggested that was taking place.
Yes, so how likely do you think it is that subletting going beyond some ancillary use has taken place prior to the change of use enforced against?
I think it's likely.
So subletting going beyond ancillary is likely from what date?
From what date? What do you mean?
From what date do you think it's likely that a level of subletting going beyond ancillary subletting has taken place on this site?
Oh, from which period?
Yeah.
I mean, I want to see what. I mean, Mr. Hakimi refers to it in January of 2020.
So before that, what evidence is there of subletting beyond ancillary subletting taking place?
I mean, I haven't seen it.
All right, thank you very much. Yes, last question or series of questions, and this relates to the difference between C1 use and use as a hostel, and in particular the questions you were asked about the Panyai case and the approach to that.
Yes.
And you said you need to meet a majority of characteristics. I wondered if you could, instead of applying that test, apply the test of an overall judgment in light of the Panyai characteristics and say what view you take in the round, applying those characteristics to the use of the site as C1 apartments.
I mean, applying those characteristics in the round, I would say that what a C1 use is different to a hostel use, as defined it in that.
And why do you say that, looking at those characteristics?
If I may go to
Yes,
it.
please do. I should have given you the.
So in relation to those, there was no dormitories. I did not see any communal or shared facilities as far as I evidenced. As far as I can say, that I didn't believe that the premises accommodated specific characteristics, certainly not the young or the homeless. In relation to, there was obviously some services on site, but there was no level of supervision as far as I could evidence. I believe that, yeah, whether payment was made by the local authority, obviously the local authority is not making payment. I made a point about that booking is done on a nightly basis, but payment is not. And that although I say that residents are transient, that they have not been placed in the accommodation. And I did not see any evidence of fire or safety certificates indicating the type of usage on site. And the display of such notice or other indicators which may indicate the type of usage, i.e. fire certificates, public fire notices, or use for staff and guests. So again, I did not see any signage in relation to the laundry room, for example.
Well, just for the sake of making sure the inspector isn't misled, if you turn up your appendix 5 and look, please, at page 40 of that, and just say what you see there.
Appendix 5, page 40. So there is signage on this image here.
So, to what extent does that alter your overall conclusion?
Well, I suppose so. There is signage here in relation to not overloading the laundry rooms.
Yeah, but
or the machines, I suppose.
and to what extent would that change your view as to the overall character of the use and whether it's as a hostel or materially the same as a?
It wouldn't change my overall view.
So just standing back, how similar would you say the use of this site is to the use of a hostel?
I would say the use is very different.
Thank you very much. Those are all of my questions in re-examination.
Thank you very much, Mr. Stratton. It's been a long cross-examination and examination. I'm not going to ask any questions, so if we can move on to conditions, please. Thank you, Mr. Daines.
Thank you very much.
So I think that the other officer who's with me, who's just slightly off screen, Mr. Kirk, has either sent or is sending the council's amendments, proposed amendments to the conditions that were sent through by the appellant around lunchtime, just after lunch. I don't know if those have been received by anyone at the appellant's end yet.
Give me 1 minute.
Thank you.
While we're waiting for that, I wonder when we could be able to do the site visit.
So I did discuss this in the break. I think there's significant flexibility on the appellant's behalf. Mr. Sutton will correct me if I'm wrong, but I think significant flexibility to suit obviously when would be convenient for you.
But when I go, there's obviously been a lot of discussion about the visits to all the rooms, getting up on the roof, looking at the amenities, available amenity space, and going down and looking at the bins and that sort of thing. Are all those areas going to be accessible? Am I going to be able to get in the rooms?
You should be able to, yes.
So I'm not sure how many rooms I need to look in. I mean, is it going to be every room, or have you got particular rooms you'd like me to look at to get the overview, or do you think I need to look at every room?
You should be able to look at most rooms, whether you need to look at every single room, but certainly it will all be accessible.
Okay. I mean, the time I was thinking about was sometime on Thursday.
Can one of you do Thursday for a site visit? Can you log me that?
This one.
Thursday morning is fine for me. My only commitment is between 2 and 2:30.
Yeah.
But I make myself available. But
So
morning Thursday.
if I said 12:30 on Thursday, would that be acceptable?
Yes.
Yeah. Yes, sir. From the council's perspective, that's fine.
Yes, sir.
Okay.
So can I just ask, whilst we're dealing with conditions, if Ms. Herwood, who I know is listening in, if she can just confirm that there are no access issues that for Thursday, perhaps she can just check that whilst we discuss conditions.
Yes, that would be very helpful. Thank you.
Yes, I'll do that.
Did the conditions come through to your side?
They were just sent, so all parties should have it.
Yes, it's just come through.
All right. So are there big changes there?
There are significant changes, although I think that the overall principle, with one exception, is the same.
Two exceptions.
Sorry, two exceptions.
I haven't got those yet. If Mr. Sutton could forward
I've
it to
just
me.
forwarded it on to you, Mr. Burnett.
Hi.
Thank you.
I've just received them, and what they are is in an email form. Would the council please send them through in track changes style so that we can see the differences? Because
I mean, they're completely rewritten compared to Mr. Sutton's. So to show track changes would be to just show me delete what Mr. Sutton did and rewrite them myself.
Okay.
Mr. Sutton had three conditions. One, sorry, I appreciate I'm out of screen while I'm saying this. One was about the existing layout, one was about occupation, and one was about a management plan.
I think what we're going to have to do is go through them one at a time.
Yeah.
And what I'm going to do it then is to ask the council to read out the condition they're proposing, and then ask your comments of generally about that. I'm sorry about this, but it would have been more helpful if you could have done it in the meantime. But so could the council read out condition 1, please?
Yes, so the first condition, sir, is headed accommodation layout and occupation, and it's a condition which reads as follows. the use hereby permitted shall cease and all associated fixtures and fittings shall be removed within 30 days of the date of failure to meet any one of the requirements set out in 1 to 4 below. 1.
If I can just say, that's basically the standard enforcement condition that if people don't comply, they have to. And I'm happy that that's a condition that would have to be imposed, and I'm sure the appellants would understand that that is a necessary condition. So if you can get onto the sort of the meaty conditions, I think.
So sorry, sir. So I can leave the layout condition, can I? And move
not
on.
leave it out. I will put that in, but I will be putting, if they don't comply, then everything has to go, basically.
Yeah, understood, sir.
Yeah, that's a standard condition. So,
So the second relates to refuse.
Yeah.
And the wording is as follows. Within 28 days from the date of this, so the preamble as above, within 28 days of the date of this decision, a layout plan detailing the refuse enclosures, including facilities for the storage of materials for recycling, showing the design, location, and external appearance shall have been submitted for written approval to the local planning authority, and the scheme shall include a timetable for its implementation. If within 11 months from the date of this decision, the local planning authority refuses to approve the scheme for failure to give a decision within the prescribed period, an appeal shall be made to and accepted as validly made by the Secretary of State, and then appeal provisions following on from that, and then requirements for accordance with it.
yeah, no, that's fine. I mean, in principle, what you're looking for is for the design of the bin store to be submitted and approved.
Yes.
What does the appellant say to that?
That's fine. There is a bin store on site. Yes, we can provide the information.
I'm sure if you want to modify that and that's part of your proposal, you can propose that to the council, whether they accept it. But in principle, the design to be just submitted and approved.
Yes.
Yeah.
Yes.
Okay. That's agreed. That's an agreed condition then.
Same mechanism as above, sir, but with the meat of it being a service apartment accommodation management plan shall have been submitted for written approval to the local planning authority and include a timetable for its implementation, and then a requirement for accordance with that below.
Yes, that's acceptable.
And I think we've discussed that in the inquiry, so that's fine. Yes, thank you.
Yeah.
And then the final one, sir, which is the new one, is soundproofing. Same mechanism, and it says within 28 days from the date of this decision, specification of sound insulation between the 3rd and 4th floors of 104 to 108 Curtain Road and between the buildings 104 to 108 Curtain Road and 1110 Curtain Road, including material and method of application in accordance with BS 8233:2014 guidance on sound insulation and noise reduction for buildings, should have been submitted for written approval to the local planning authority, and the scheme should include a timetable for its implementation and then mechanisms flowing.
Can I have your views on that, please, from the appellant side?
Before that goes to Mr. Sutton, I mean, first of all, so you would have had to find that there was that was necessary to make the development acceptable in terms of noise. So, of course, our position is that there is no undue harm or unacceptable harm in terms of noise. So you'd have to reach that finding before there would be a basis for the condition in order for the condition to be lawful. As to the mechanics that are proposed, can I pass over to Mr. Sutton, because I've not been involved at all in that discussion.
Thank you, Mr. Grant. Yes, I was going to make the same point. I'm just reading again. Specification.
Can I step in and say, was it 1 month you wanted it to be submitted and approved?
28 days, yes. So
Yeah,
essentially a month.
That seemed a little short, to be honest. If it found to be necessary, it will take quite a lot of investigation of what's there at the moment and what the sound level is between the floors anyway. So I would have thought that would be quite hard to achieve within 28 days, to be honest. I would have thought a longer time would be more necessary.
Yes. So I don't think we'd object to a longer time period for that.
Okay.
But we do say it's necessary because otherwise it's unconditioned in terms of the noise environment. And obviously you've heard our evidence on that, and you've heard Mr. Grant in your formal view on whether it's necessary or not.
Yeah.
Okay.
I wonder if Mr. Sutton can indicate what he would regard as a realistic time frame in order for that sort of a scheme to be to be formulated and formalised.
Yes, I mean, if my client isn't aware of the existing specifications, then there'll have to be some invasive works to check. So I would suggest 3 months would be more appropriate.
It sounds reasonable to me, to be perfectly honest.
Yes, absolutely, sir. Agreed.
Okay. Is there any other points you wish to make from the appellant side, anybody?
Not from me, unless Mr. Sutton has anything.
No, sir.
Okay, thank you. Are there any other conditions? Was it 3?
No, that's it, sir. That's the lot.
And do the appellants have any conditions you want to propose? Any addition to that?
No additional conditions, sir.
Okay, thank you very much. If you want to add conditions to the closing submissions, I don't mind you doing that if you want to sort of formulate them in that way, and I can adjust them, but I can otherwise sort that out if the appeal is approved. That really brings me to the end of that, and I think that probably brings us to the end of the inquiry if we're going to follow the route of having the closing submitted in writing, which I think we will, and the cost application. What have you thought about the timescale you want in terms of submitting the closing submission? I think that will go to you, Mr. Strickland, because you'll be submitting the first one, as it were.
Well, so my position is that I'd like to do it sooner rather than later, because I frankly plan to complete the closing tonight. I'm going into some quite heavy litigation tomorrow, and I'd rather not think about it.
Right. So when can you submit it?
Tomorrow.
Tomorrow. Okay. I'm very happy for it to be tomorrow. And Mr. Grant, when can you submit yours? Well, you've got the cost application. Yes. When can you submit your closing and reply to the cost application?
Can we? It should be fine by close of play on Wednesday. But so would you say till noon on Thursday, just to give me an extra bit of breathing space?
Okay. Are you happy with that, Mr. Stratton? Does that cause you any problems?
No, sir, it doesn't. I'll be in the same place noon on Thursday as I will tomorrow.
It'll probably be Wednesday, but just in case.
All right. So just to remind you that I will need the cost application that's gone to Mr. Stratton already. I'll need obviously the reply from Mr. Stratton, and then I need your reply as well, and then obviously the closing submissions from each of you. I think that's an acceptable basis. I'll probably try and get that just confirmed in an email to you. Not sure whether I'll beat you tonight, Mr. In fact, I'm sure I won't. But anyway, we can take that as the agreed timetable. That you'll submit by end of play tomorrow. Then Mr. Grant will submit by noon on Thursday. Is there anything else anybody wishes to add then before we close the inquiry?
Not for me. Thank you very much indeed.
No, sir, thank you.
All right. I'd just like to say to everybody, thank you very much. And I know this is certainly not my preferred method of inquiry, so thank you for bearing with it and with the 1 or 2 glitches that we've had, especially on the first day, second day when I had that music playing. I still have no idea. It came from all right. But anyway, thank you all very much. The inquiry is closed.
Thank you.
Thank you.
Thank you.